Thank you. Good morning. Good morning, everyone. Thank you. Right. Put the open for business sign out. Your name? Will. Nice to meet you, sir. And again, Gabriel Rivas. Yes, I remember. All right. Here we go. Where would you like this? Anywhere? Right there. Thank you. Let me have my stamp. Yeah. Yeah. Hi. You're gonna help me turn the computer on?
Setting up everything for you.
It's all ready to go.
Yes.
Thank you. Thank you.
You want me to do everything? That can do that.
Anyone who's appearing by Zoom, I just don't know that. I'll put that down here. If we have participants that are trying to Zoom in or attorneys or things like that, I guess I need to know that, you know. Your name again?
Yeah.
I remember you were here the last time I was here. It's been about a year and a half ago.
Yeah.
I think so. All right.
We're ready to start. Let's say change the camera.
Well, let me ask, from the clerk's perspective, we'll have the public defender, they'll be in the, so our public, that's okay. Our clerk's representative, okay. All right. And is this today's calendar? So we. Historically, what I do is I read the charge to them and then check the narrative for probable cause. We'll take input from both sides. The public defender will be in the jail with the individuals. Do they also have an interpreter in case they need it over there?
Yes, Your Honor, interpreter present, Judge.
Yes.
Good morning.
Great. Okay. I saw you earlier. Thank you.
Welcome, Judge.
This is what?
Priors for this first round of cases for domestic violence.
Okay. And all of these first cases are DV? Okay. I'll have to put on my DV cap. Right. All right. They've all been read their rights before today's. I'm ready.
All rise.
Todo el mundo de pie.
Please raise your right hands.
Por favor, levanten la mano derecha.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Juran, prometen que van a decir la verdad, únicamente la verdad, solo la verdad.
Hey, I do, gentlemen. I do.
Thank you. You may be seated. Good morning, everyone. My name is Judge Lawrence King. I'm the weekend duty judge for today's proceeding. We have the public defender. Your name, ma'am?
Good morning, Your Honor. Assistant Public Defender Giselle Landron.
Thank you, Ms. Landron. We have present in the courtroom our clerk, assistant, the pretrial services individual. Your name, ma'am? Campbell. Ms. Campbell's here. We have our assistant state attorneys, Rivas and Lovelace, and we are ready to proceed, I think. The first cases on the calendar are going to be those that are related to domestic violence, alleged. And the first defendant is Marlene Acosta. Marlene Acosta.
Sir.
Thank you, ma'am. Ma'am, you've been charged with a violation of Florida statute 784.03 misdemeanor battery. Taking a quick look at the offensive form affidavit. Okay. Court finds probable cause in this case for the arrest. In this case, ma'am, there would be certain provisions the court might consider. Is she eligible for release? She qualifies for pretrial service release. If you're eligible and actually are released, ma'am, you may not engage in any criminal activity. You may not possess or be in possession of any illegal drugs. You may not use or possess any firearms or guns at any time. You may not have any direct or indirect contact with John O. Kenway. If I said that properly, I hope I didn't mispronounce it. You must stay at least 500 feet away from the victim's home or place of employment. Do you cohabitate? Do you live with this gentleman or no?
I do for now, but I could get moved away from him.
Ms. Acosta advised me she has another address where she could live at, so we're requesting pretrial services, Your Honor.
Pretrial services is granted. Under the circumstances, you cannot return to the home where you resided with the petitioner in this case. Defendant may return only one time, though, to pick up your personal belongings, but you must be in the accompaniment of a police officer. Defendant is allowed to have contact with the victim. No. And if I filled that out correctly, in the event, I'm reading the last paragraph here. No. So, Andy, correctly? And right. So how we do it. And all right, I've signed the order of pretrial release conditions, and I'm going to put pretrial right there. I'm sorry, I'm asking from BTS alternate.
What is the alternate bond?
They would be asking for an alternate bond, standard bond of $1,000.
Any objection by the public defender?
No, Your Honor.
$1,000. Ma'am. Thank you. Yes, relief is strong.
Judge, may we assume that the public defender has been provisionally appointed for all of these bond hearings, Your Honor?
Yes. Thank you. All right. In this case, Ms. Strong will be charged with misdemeanor of the first degree petty theft in violation of Florida Statute 812.014, subsection 2, subsection F, and contributing to the delinquency of a minor child, which is a first degree misdemeanor in violation of Florida Statute 827.04. This occurred at the Nordstroms on 19507 Biscayne Boulevard in Aventura, allegedly. Involved a shoplifting incident obtained by and through surveillance. Okay, in this case, the juveniles involved, a 13-year-old and a 14-year-old, were seen also involved in the attempt to shoplift by cutting tags from the clothing items. And then they were actually apprehended with specific items. Under the circumstance, the court finds probable cause for the counts against Ms. Strong. Is she eligible for pretrial services?
State would be asking for bond here of $1,000 on contributing to delinquency of a minor and $250 on petty theft. The defendant was using her own children as pawns in a scheme to steal what is unrelated to any sort of minor needs.
As to count one, $1,000 bond as to count.
Judge, if I may?
Yes, ma'am.
Yes, Judge. Here we are asking for Ms. Strong to be released outright. She has, or rather released on her own recognizance. She has no criminal priors. The nature of these offenses are not dangerous. She does not pose a danger to the community. So we're asking for her to be released on her own recognizance. In the alternative, if Your Honor will grant her pretrial services so that she can go back to her address without having to pay a bond. But she does not pose a danger to the community, Your Honor. She has no priors.
State.
State would argue that she's proves at the very least, while we didn't issue a stay away order from her own children in this case, what we do see is her using her own children in a scheme to steal things. That is a danger to the community. It's a danger to her kids, as cited by the A form. And thus we're asking for a bond here of $1,000 plus $250.
Overruled as to this public defender's request at this time. Alternate bond is scheduled count 1, 1,000, count 2, 200. And in this case, from the clerk's perspective, the last item on the stay away order, you may not go back to the Nordstrom's location, ma'am, at any time at 19507 Biscayne Boulevard, Aventura, Florida. It says the order shall remain in effect until closed modified by the court or for a period of. So I'll just initial next to that, but I'm circling as modified by the court.
I'm sorry, Your Honor, what's the disposition for Ms. Strong?
Ms. who?
Ms. Strong,
What is?
Strong, the disposition is probable cause was found. And I'm giving her pretrial services with an alternate bond, so she is eligible for pretrial services, yes?
Yes, Ron.
She is. Alternate bond 1,000, count 1, 200, count 2. Next case.
Your Honor, I'm sorry, count 1 is the petty theft.
Sorry, yes, please, all of those defendants who are in the area over there with your public defender, she is there to assist and help you. Please don't be discussing your case with the court, and anything you say, don't forget, is being listened to by our state's attorneys here who are prosecuting the case potentially against you. So you want to remain silent and only discuss the matter with your attorney. You want me to? I'm sorry. Oh, there it is. Yes. That was Marley. Yes. Thank you. Thank you.
Ms. Young, what were you saying?
We were asking the alternate bonds.
It's pretrial alternate bond, count 1, 1,000, count 2, 200.
Torrance, we were asking because count 1 is, we have count 1 as the petty theft. That's why we was asking.
Did I get it? I put them in the wrong location. I apologize. Thank you. Correction. It's 200 for count 1 and 1,000 for count 2. My fault. Sorry about that.
Thank you.
Makaya Vandiver, charged with battery of domestic violence in violation of Florida Statute 784.03 sub 1 sub A sub 1. This occurred in Miami Gardens. Okay. Having read the arrest form in this case, I find that probable cause exists for the misdemeanor battery charge of domestic violence. In this case, is she eligible for release? Yes? Say again. She does qualify for pretrial services. Any objection by the state?
State would be arguing, no objection, but we'd be arguing for a $2,000 bond, alternate bond to both counts.
Any objection by the public defender?
No, Your Honor, we were going to request pretrial services.
Thank you. Pretrial services granted. In this case, ma'am, if you are released, you may not engage in any criminal activity, nor possess any illegal drugs. You may not possess or be in possession of any firearms, guns, weapons, or ammunition. And you must immediately surrender such to the local police department and obtain a receipt if you indeed are an owner of firearms or weapons such as those. Defendant is prohibited from having any direct or indirect contact with the following persons. In this case, it would be, if I'm not mistaken, Monique Latoya Sapp.
There is another count here, Your Honor.
Did you reside or are you residing, ma'am, at this time with Ms. Sapp?
Your Honor, she was. I've confirmed with her that she has a different address that she can stay at and provide to pretrial services.
It says 2 counts, but I only see the one.
The striking of the child, Your Honor.
On this arrest form, there's only 1 count, misdemeanor battery, unless I'm nuts.
Should say 2 counts.
It's 2. Oh, there it is, right there. My eyes. 2 counts of the same statute, 784.031A1. So alternate bond as to the second count? Any?
I'd ask for 2,000, Your Honor.
$2,000 alternate bond on count 2. And let me ask the clerk just briefly on the back. You handle that or I initial that or no? We're good? Right on the front. Okay, good. Just want to make sure they hadn't changed anything since the last time I was here.
Your Honor, what's the alternate bond on count 1?
Count 1 is 2,000. Count 2 is 2,000.
Thank you.
Good luck to you, man. Next case would be the case of Karina Sotelo Garcia.
Your Honor, she'll require the use of the Spanish interpreter, and we also have a probable cause argument on this one.
Thank you. We
Thank
have
you,
our,
Professor Counsel.
good morning, ma'am. You've been
Buenos días,
charged,
señora.
you've been charged with a misdemeanor of the first degree battery, Florida statute 784.03. Take a minute to review the arrest affidavit.
Señora, usted enfrenta un cargo por agresión física, delito menor en quebrantamiento del estatuto 784.03. Un momentico, estoy revisando el informe del arresto, dice el señor juez.
All right. We'll hear from the public defender at this time. Thank you.
Thank you, Your Honor. Yes, our probable cause argument here is that there is no evidence that Ms. Sotelo Garcia was actually the primary aggressor. The only witness that indicated that she was actually found to be not credible by the officers that were on the scene. While they stated that she had some injuries or some marks, those injuries or marks could clearly indicate that she was just defending herself. Here we're asking for her to be released outright.
La defensa está diciendo que no hay motivo fundado para el arresto. Están pidiendo que simplemente le pongan en libertad porque en realidad ella estaba tratando de defenderse. Es el argumento de la defensa.
State.
Your Honor, I would argue here that there are 2 sources. While yes, the civilian witness did end up changing her story again, it also matches the initial, telling of what occurred matches what the victim said occurred. So we have 2 different sources. While you can question the reliability of one, you could certainly argue that, and I am arguing, that there are 2 sources here telling the same events of what occurred.
Dice el fiscal, pero señoría, tenga en cuenta, hay dos fuentes que están narrando la misma historia.
Court finds probable cause in this case. Thank you very much. Well argued by both of you. At this time, is she eligible for pretrial release?
Yes.
She is eligible for pretrial services release. The bond alternate requested by the state is?
$1,000.
I'm going to set a $1,000 alternate bond as to count one. And in this case, ma'am, if you are released, you shall not engage in any criminal activity. You will not possess any illegal drugs. You will not purchase or carry any firearms, guns, weapons, or ammunition. And if you own such things, you must immediately surrender them to the nearest police station and obtain a receipt for the court. Under the
Señora, I'm sorry, Judge, if I may just interpret. Thank you, Judge. Thank you, Honor. Hay motivo fundado para el arresto. Se le autoriza que vaya al servicio previo al juicio. Como alternativa, puede pagar $1,000 de fianza. En cuanto al primer cargo, si llega a ser puesto en libertad, tiene que, no podrá estar en tendencia de ningún arma de fuego, tampoco podrá ejercer ninguna actividad ilícita, tampoco podrá tener armas de fuego ni municiones. Y si tiene algún arma de fuego o salvoconducto para armas, tiene que entregarlo al departamento de policía más cercano y radicar el recibo que le den allá ante la corte.
You shall have no contact with Dixon Alfonso Amador.
No podrá tener ningún tipo de contacto con Dixon Alfonso Amador.
And if you reside with him, you may return only one time to receive some personal belongings with the accompaniment of a police officer.
Y si vive con él, solamente te podrá regresar acompañada de un oficial de policía a regresar a obtener o a sacar sus pertenencias.
You must stay away at least 500 feet from the victim's home, place of employment, or school at all times.
Y en todo momento tendrá que permanecer por lo menos a 500 pies de distancia de donde la presunta víctima vive, trabaja o estudia.
Do you understand, ma'am?
¿Entiende eso, señora?
Sí.
Yes.
Good luck to you.
Buena suerte.
Good morning, this is Mr. Hernandez. He'll require the use of the Spanish interpreter, Your Honor.
Hernandez or Mr. Mondesir?
Your Honor, can we pass Mr. Mondesir? He's coming from out of facility.
Yes, we'll pass it. The case of Canel Hernandez. Mr. Hernandez, you've been charged with a misdemeanor battery in violation of Florida Statute 784.031A1.
Señor, buenos días, señor Hernández. Usted enfrenta un cargo por agresión física, delito menor, en quebrantamiento del estatuto 784.03.
This time I've read the arrest form affidavit.
Ya leí el informe del arresto.
In this case, the court finds probable cause based on the arrest form.
Este despacho haya que motivo fundado a la luz de lo que aparece en el informe del arresto.
He is eligible for pretrial release conditions. Is there an alternate bond that the state wishes to recommend?
$1,000.
Califica para el servicio previo al juicio como alternativa $1,000 de fianza.
In this case, Ms. Landry, I'm going to presume there's no objection if I don't hear something from you, just to speed things along, all right?
Correct, Your Honor.
In this case, sir, if you are eligible for release, you will not have engaged in any criminal activity. Once you're released, you will not possess any illegal drugs. You shall not possess any firearms, guns, weapons, or ammunition. And if you own some of these items, you must immediately turn them into the nearest police station and file a receipt with the court that you did so. You're prohibited from having any direct or indirect contact with the following persons. In this case,
Señor, a usted se le prohíbe tener ningún tipo de, participar de ningún tipo de actividad delictiva, tampoco podrá estar en tenencia de armas, armas de fuego ni municiones, tampoco podrá consumir ni portar ningún tipo de drogas ilícitas. Cualquier arma o arma de fuego que usted tendrá que entregarla de inmediato a la estación de policía más cercana. El recibo que le den tendrá que radicarlo ante el juzgado, tribunal, corte o como le llamen.
You'll have no contact and must stay away at least 500 feet from the victim alleged in this case, Jocelyn Julia Barrio de la Paz.
Y en todo momento tendrá que mantenerse por lo menos a 500 pies de distancia de la presunta víctima, en este caso Julia Barrios de la Paz.
You can only return to the residence once to retrieve any items if you are living with her at that location. However, you must go in the accompaniment of a police officer, and you can only take personal and business-related paperwork and items such as personal health items and medication and clothing, but it's a very limited amount of things that you can remove from the property.
Entonces, si usted vive con ella, podrá regresar a recoger, a sacar sus pertenencias solamente acompañado de un policía. Usted no puede ir solo y solamente para que saque su medicina, documentos de trabajo, herramientas de trabajo. Son cosas muy limitadas que podrá sacar solamente.
Good luck to you.
Buena suerte.
Next case, Bryce Martinez. Good morning, sir. At this time, you've been charged with a misdemeanor battery causing bodily harm in violation of Florida Statute 784-031A2, one count. This occurred at 241 East 6th Street, alleged. In this case, there was an altercation between father and son, it appears. Court finds probable cause for the alleged charge. And in this case, is he eligible? Yes, he is for pretrial release. He is not. No. He had a past battery under the circumstances. So under this, what would be the suggested bond by the state?
State's going to be asking for a bond of $5,000 here. Defendant, according to the A form, the defendant was angered by the fact his father didn't give him the keys, proceeded to beat him. As the father fell to the ground, he got on top of his own father and continued to beat on him more. The defendant has been convicted of a robbery with a firearm, which is punishable by life. Due to these circumstances, the state's asking for that $5,000 bond.
I may be heard, Your Honor.
Okay.
Your Honor, Mr. Martinez's last conviction was in 2016. Since then, he has not been convicted of any other crimes. While here the allegations the state is posing, in this particular case, a standard bond would be sufficient to ensure his appearance in court. There is no reason for an elevated bond in this case.
The state will note that the defendant in the past has had to have his probation, two probations, which he was serving on at the same time, modified.
The standard bond, Ms. Leandre.
Yes, the standard bond, I believe, is $2,000, Your Honor.
At this time, the court finds persuasive arguments on both sides. I'll lower this bond to $2,500. Under the circumstances, sir, do you reside with your father?
He does not, Your Honor. I confirmed with Mr. Martinez
You confirmed yes, he does?
that he does not.
He does not. All right, so he will have no contact with him. The victim in this case, Bryce Martinez Garcia Sr., I would say. He cannot be within 500 feet of him, his place of home, employment, or at school. Therefore, he will have no need to go back to the residence where the victim alleged resides. Bond is set at $2,500. Good luck to you, sir. Next case, Nodar Bukya. Nodar Bukya, B-U-K-Y-A. How are you, sir? Good morning. At this time, you've been charged with a misdemeanor battery in the first degree. One count, 784.03 Florida statutes. This occurred at 17600 North Bay Road, Sunny Isles Beach, Florida, as alleged. In this case, court finds probable cause for the arrest and charges. Is he eligible for pretrial? He is what? He's not eligible at this time. I'm being advised by pretrial services for release. Under those circumstances, does the state have a bond request?
They would be asking for $2,500 here.
This time, the bond is set at $2,500. If you are eligible and are able to make bond, in this case, Mr. Bukya, you will not possess any firearms, guns, weapons, or ammunition. You'll not be in possession of any illegal drugs. You'll not have or engage in any criminal activity. You'll have no contact whatsoever with Marikena Motion Salera, if I have said that correctly, the victim alleged in this case. Apparently, you do cohabitate with her, so you must, if you wish, go back only in the accompaniment of a police officer to retrieve some personal belongings, which are stated in the order that I'm signing here. You shall all, thereafter, you shall stay at least 500 feet away from the victim, their home, place of employment, and or school until further order of this court. Good luck to you, sir. Thank you. Next case, Jose San Martin.
Your Honor, Mr. San Martin also has an open felony. He'll be back on your bond hearing calendar.
Thank you. He's been charged with a misdemeanor in the first degree, touching or striking and battery, 784.031A1. Taking a look at the arrest form. Court finds probable cause for the arrest. Bond.
State would be asking in the battery case. There is the open felony is associated with this case. It's charged with a strong arm robbery and the same facts. The state would be asking for a $5,000 bond on the misdemeanor aspect of this.
Approved.
Judge, the defense here requests a dollar bond, given that he's going to be held on the felony anyway, and the bond amount there would be sufficient to ensure his appearance in court for both of these cases.
Well, until we get to the felony, I'm not sure whether or not probable cause exists for the felony. So under the circumstances, for now, I'm going to issue a $5,000 bond. You might want to readdress that with me at that time. Momentarily, we'll deal with that. If you're eligible for release, Mr. San Martin, you'll have no contact whatsoever with the victim in this case. That would be Ms. Sanchez. Second, you'll be engaged in no criminal activity whatsoever. You'll not possess or have any illegal drugs. You'll not purchase or carry any firearms, guns, weapons, or ammunition. And if you own such things, you must return those items to the local police department, or your nearest police department, and get a receipt for the tender of those. Apparently, you do not reside and cohabitate with this individual victim. So therefore, you'll have no need to go back to the premises whatsoever where she resides. You must stay away from her at all times, at least 500 feet from her place of residence, from her individual location and employment or school. Good luck to you, sir. Next case, Nelson Mandesir, we had called earlier.
Your Honor, he's probably gonna be a reset for tomorrow. He's coming from out of facility. He hasn't made it here yet.
Good morning. Thank you. Reset Sunday for, which would be May 18th, if I'm not mistaken.
Judge, do you have a Joseph Garcia? He was number 9 on our calendar. It was an add-on.
Do I have Joseph? Say
Yes.
again?
Joseph Garcia.
Yes, I have Joseph Garcia.
Okay.
Just 5 minutes.
Could I have a case number, please?
Case number would be 2024-14188-04.
Court case number. Oh, it's the DB one. I'm sorry. My apologies. Yeah.
Yes. Okay. Ms. Sanchez is available by Zoom, or is she?
Yes, hi, good morning, Your Honor. I was writing on the chat trying to speak for them to let me speak when they had called Jose San Martin, but nobody has seen me till after you passed the case.
That's okay. I'd like to hear from you at this time, please. Thank you.
I just want to make sure that the stay away order sticks. He is very dangerous to me. It's not the first time I have to press charges against him. You know, me as a good-hearted person, I always go and drop the charges. From him, you know, begging me, please, please, please. But this time it has gotten out of hand. He's took out guns on me. He's shown up to my place and destroyed my home. I've had to move several times. Like, this is just an ongoing thing, and I at this point I fear for my life, and I need you guys to please, like, be harder on this. Like, I have a lot to lose right now, and I don't need him coming nowhere near me. He was calling me last night from the jail, begging me to please drop the charges. And I just need him to stay away from me and turn in the gun that he has, because I'm in danger. I'm scared.
Thank you. The charges are not going to be dropped unless the state were to do so for a good cause shown. Number 2, he's under a domestic violence injunction as issued by this court. 3, he may make bond in this case, but he is prohibited from returning whatsoever. And if he were to do so, you immediately contact Miami-Dade Police. All right.
Good morning, Ms. Sanchez. This is Assistant State Attorney Will Lopez from the State Attorney's Office. I will also note that he is facing a felony charge later this afternoon that he will be on bond for, and we will be asking for another stay away order in that case as well.
Okay, perfect. Thank you so much.
Of course.
Okay. I had one last case. Ms. Landrin asked about Joseph Garcia. He's standing in front of us now. He was picked up on a warrant. Is that correct? Okay. And as I understand it, the warrant amount was how much?
All of them,
Right.
and we set them on compliance calendar.
Great. Any objection by the state to setting this ROR on the civil compliance calendar? The date would be June 4th, 2025 at 1 p.m.
No objection, Your Honor.
At the Courthouse Center, courtroom 2-A. And I'd like to enter that right here, Judge. Right.
far off.
Thank you. Okay,
As she also needs to set aside the warrant.
we're going to set aside the domestic violence warrant that was outstanding for his arrest.
He needs to re-enroll in that program. That's why he got the.
Right, Mr. Garcia, you have to re-enroll in the advocate program so that they don't issue another warrant for your arrest for failing to do so. That's what got you into this mess here today. Backing off, which one? This one? Yeah, sorry.
Yes.
I think it's the first one, yes. I'm checking off domestic violence batterers assessment and intervention program, anger management.
He does that before.
Right, and Madam Public Defender, if you'll instruct him that he really needs to re-enroll in the advocate program before the hearing, June 4th, 2025, okay?
Yes, Your Honor.
Thank you. Okay. Now you were saying?
That's good morning.
Hi.
This is your calendar, already marked on it, find out. The date of the meeting is what I'm gonna do. Yeah, my presentation.
Okay, thank you.
So, you can write find out here.
Thank you. Do I need to announce the case number or no?
You can, just for the record.
Okay, for the record, we have our misdemeanor calendar and we have some bond outs already. So we're going to sign those first to speed things along. The first one is Elvin Ariel Estrada Montino. And I said bond out initialed, okay? The next one would be Miguel Artu Pomares Mendoza. Thank you, yes. The first individual is Elvin Ariel Estrada Montino. Okay, good.
Yes.
Thank you.
Judge, have a good day.
Thank you for helping me. Appreciate it. These are my cases here. Like start on them.
Yes.
That's okay.
Got it.
Good morning, Judge King. This is Joanne Hennessy. I'm here with the City of Miami Beach for the misdemeanor, the jail arraignment calendar.
Good to see you again. How have you been?
I've been well, thank you, Your Honor.
Last time I was here, you were also representing the city of Miami Beach, so I remember.
And Your Honor, I have another.
Thank you.
Great, great. I'm going to rely on you, but yes.
No problem.
Thank you.
Of course.
Madam Public Defender, are you ready to go?
Yes, Your Honor.
Okay, forward to speaking to all of you in the next few minutes. The first case is the case of Made Aguiar, Aguiar. And Madam Clerk, you want me to enter right here, right?
Yes.
Whatever we do.
If you want to go out, in the city, whatever, it's right here. It's only if you want to close it, right here.
Got it.
You gotta stay.
In this case.
And you are, yes. I'll be up and down most of the time, Your Honor.
Thank you. Mr. Aguiar, you've been charged in this matter with criminal mischief, less than 1,000, but more than $200 in violation of Florida Statute 806-131B2. It's occurred at a Murphy's Express gas station. Find probable cause for the arrest in this case. Yes.
Your Honor, at this point, we'd be making a probable cause argument specifically as to there's no value alleged here. Mr. Aguiar is accused of committing a criminal mischief in the first degree, which requires the officers to allege an amount of damage beyond $200. That amount must be alleged in the A form. They can't just say what was damaged. And because there's no dollar value assigned here, at best, there is PC for the second degree misdemeanor of criminal mischief. So we'd be asking for pretrial services with an alternate bond for a second degree misdemeanor of $500.
State?
State would argue that it only follows that even when considering the four corners of the A form, the value of the objects described would be more than $200, and thus there's probable cause.
I concur. In this case, probable cause found. And we're going to, what's the state's offer?
States, the state would be looking for a $500 bond here, Your Honor.
$500 bond it is. And we'll schedule that. I'm entering a not guilty plea on his behalf. If you make bond, sir, good luck to you. You must stay away at all times from the Murphy Express gas station if you're released at 17700 South Dixie Highway, Miami, Florida, 33176. Good luck to you.
Your Honor, we'd be asking an alternate if we could do pretrial services. Mr. Aguilar is indigent and would not be able to afford a $500 bond. So we're asking in the alternate if Your Honor would be willing to grant pretrial services as well.
State.
The state would object here. He's been convicted of a domestic violence injunction in 2023, another domestic violence injunction in 2024. He's got a withhold on a battery on an elderly, and another withhold on a domestic violence injunction and a trespass after warning. We're seeing him completely disregard the court's orders a number of times.
Alternate bond request by the public defender denied. Thank you. Next case, this one, actually, Danielle.
Yeah.
Thank you, sorry. Danielle Marie Payton. Danielle Marie Payton. Ms. Payton, good morning. This was a warrant she was picked up on by the officers, $1,000 bond that time. In this case, ma'am, all right, so she was taken into custody for the warrant. Does the state have any need to retain her at this time?
Yes, Your Honor. Pursuant to statute, Florida statute 903.046(2D), when a defendant fails to appear on a required court date, which results in the issuance of a bench warrant, the defendant is not eligible for a recognizant bond or any form of bond which does not require a monetary undertaking or commitment equal to or greater than $2,000, twice the value of the monetary commitment we're undertaking the original bond. Here, we'd be asking for the $2,000 amount, considering she gets warranted.
Madam Public Defender?
Yes, Your Honor. It is our position that here she was originally charged with a second degree misdemeanor with the standard bond is a $500 bond. In this case, we think the standard bond is sufficient to ensure her appearance in court. There's no reason to elevate such bond.
Your Honor, if I may?
You may.
An issuance of a standard bond here would violate subsection D of 903.046. Here, the greater than 2,000 from where I stopped earlier, or twice the value of the monetary commitment we're undertaking the bond, which is ever greater. So here, it's not a raising of standard bond. It is the bond for the bench warrant. So it's 2,000 as required by statute.
Thank you. At this time, I concur with the state. The bond will be set at $2,000. Madam Clerk, just so I'm.
Are you elevating the bond?
Yes, ma'am. $2,000. And not guilty. No?
Yeah, the bench warrant amount is 1,000.
Correct.
That is correct. But because that warrant was issued for your arrest for your failure to appear, the new statute that is referred to by the state elevates and allows for the court to elevate that. So the bond is $2,000. Good luck to you. Thank you.
That's fine.
Next case. I don't want to listen. Thank you. Amaris Bell Mullings. Thank you, ma'am. At this time, you'll be charged with misdemeanor count of the second degree, disorderly conduct, breach of the peace in violation of Florida Statute 877.03. Taking a moment here to read the arrest affidavit. Find probable cause. And under the circumstances, is there a bond?
State would be asking for standard $150.
$150 bond is,
Maybe call my boyfriend.
Your Honor, in the alternate, can she be granted pretrial services? She has no criminal priors.
any objection by
They would have no objection to pretrial services.
approved? Thank you, Madam Clerk. I'll put it
The alternate bond.
150. And appropriately entered not guilty.
Yes.
Yes, thank you. That's what I thought. Do
Can you ask if they have a phone number to contact them, please?
you have a phone number that you can be contacted at, ma'am?
My phone is empty, but yes.
Contact you from the pretrial services department.
Yes.
What? Your Honor, a phone number for Miss Mullings. She said her phone is at intake, so I don't know if she's gonna be released. Then should they be able to contact her?
Yeah, can contact someone that she knows.
Someone that she knows. Does she have a phone number for someone she knows? Or does she know her?
Someone they can call for your address.
What she got? Pretrial?
Mhm.
Yeah.
What's the phone number?
786
Mm-hmm.
720
Mm-hmm.
0117. That's my mom.
0117. Your Honor, you ready for the number? 786-720-0117.
Thank you.
And the name, please?
What's her name?
Nakara.
I'm sorry?
Nakara.
What's her last name?
Nakara Hall.
Nakara Hall, Your Honor.
Great. And I put it on there too as well. Fine.
Thank you.
Thank you. Next case, Caitlin Mary Fink.
Stay away from it.
Ms. Fink, in this case, you've been charged with a misdemeanor of the first degree, criminal mischief and destruction of property less than $1,000, but more than 200 in violation of Florida Statute 80613, sub 1, sub B, sub 2. In this case, there was a disturbance at the location of 1237 Northeast 128th Street, Unit 25, as alleged. And at that time, there was a dispute between you and some other individual. Looking for the name. She destroyed property that was valued at approximately $225. I find probable cause. In this case, does the state have an offer?
State would be, in this case, asking for a bond of $500. While there is no local priors, the defendant is from outside of Miami-Dade County, and I cannot at this time testify as to whether she's got priors elsewhere.
Okay. And in many of these cases, the state's not at this point willing to make an offer.
Many of them, yes. But
Okay. if you do.
I'll let you know.
advise me. Thank you. Okay. The bond in this case would be set at $500. Also, in this case,
They removed the defendant, Your Honor. We're gonna need to get her back.
say again.
They removed the defendant. They swapped defendants. We're gonna need to get her back.
Okay, we're gonna need to get back the defendant, Miss Landrin. I don't know what happened. We want Miss Fink back in front of us.
I'll alert corrections, Your Honor, one moment.
Thank you, Miss Fink. The bond's set at $500. I've entered a not guilty plea on your behalf. Also, we have issued a stay away order. You may not at any time be within 500 feet of Shandy McCauley. Do you understand?
Say it again.
Yes, ma'am. Understand? Good luck, ma'am. Thank you. Next case. Tylin Clarice Trevelong. She was apparently picked up on a warrant. Judge Cuervo has issued several warrants for her arrest in the past. At this time, state, what's your position?
State's position, considering she also has a felony, open felony as well, state's position would be a bond of $5,000.
If I may, Your Honor?
I'm sorry, state, we don't have an open felony on the jail card.
I've got a case number if that would help. I've got F25 7249. It's cocaine possession.
If I may, Your Honor?
Yes.
I believe that the standard amount that already issued on this bench warrant of $2,000 is more than sufficient to ensure her appearance in court, as is indicated on the arrest form and as is indicated in the criminal justice system. Ms. Prevlong is homeless, so a bond amount of $5,000 is not going to ensure her appearance in court any more than a $2,000 bond amount that's already been issued for this bench warrant. And in the fact that she has a felony also indicates she's going to be held on that as well. There's no need for an elevated bond in this case.
State will note that the felony was picked up while after the misdemeanor case was occurred. So the felony occurred after the misdemeanor. And I may be able to check if you give me one moment. It might have even been picked up while she was out on this bench warrant. No. The felony was open before the bench warrant.
Bond would be set at $2,500.
Your Honor, you placing a hold on the felony?
State would be asking for that.
Is that felony going to be heard later today or tomorrow?
No, she will have to go before her judge on Monday, Your Honor.
Hold for felony Monday, which would be the 19th of May. Very good. Thank you. Next case. Matter of Ada Brendales.
Okay. That's the thing, Sean. That's why she got picked up. We scratch it out. Put it here.
I will. Give me 1 second, Miss Landrin. And let's see.
When you see the files, just put it on the case history sheet.
Got it.
Mhm. Just put a big S.
Sorry about that. All right. Okay, all I have here is looks like a ticket in violation of Florida statute 322.03. Expired driver's license at the time.
That's correct, Your Honor. But it is a bench warrant, so again, the $2,000 amount.
$2,000 bond is set. I'm entering a plea of not guilty on her behalf. Good
Your
luck.
Honor, it's the defense position that Your Honor could keep the bench warrant amount as issued with the $1,000. You have the discretion to do so. This is a traffic offense. I don't see the need for there to be an elevated $2,000 bond for a traffic offense, Your Honor.
The state would go back to 903.046. The bench warrant gets superseded by the requirement for bond. It's an issuance. The bench warrant amount does not hold.
Bond set at $2,000. Thank you. Next case, Karen Yolanda Ruiz Arganal.
She also has a hold for immigration.
Thank you. He was charged with, well, we'll have to see her there, please.
Corrections went to grab her, Your Honor. This is Miss Karen Joanna Ruiz, Your Honor.
Thank you. In this case, you've been charged with a violation of having no valid driver's license in Florida Chapter 322.03 statute. At this time, is the state wish a bond set in the matter?
We can RMR here, Your Honor.
Your Honor, we are asking for the standard bond to be issued here, given that she does have an immigration hold. If she's ROR'd, she will not have the opportunity to either litigate this case and will likely go directly into immigration custody.
We can do it over.
Or a dollar bond in this case, given the hold, so that Ms. Ruiz can decide if she'd like to go directly into immigration custody or close out this case prior to doing so.
You can close it out now if she'd like.
Your Honor, I don't have the time to advise her properly on a case like this, so we're just asking for a dollar bond.
State has no objection. At this time, I don't have enough information on this case to make an offer.
$1 bond and hold for immigration. There we go. Next case. The case of Janet Gattani. Ms. Gattani, in this case, looks like she was picked up on a bench warrant.
So she was picked up on 2 bench warrants, but was also driving while license suspended again.
Okay, we have different case numbers. Case AJW DCSE, case number AKVQ9LE. State's position is?
State's position is that on the DWLS bench warrant should be $2,500. The no motor vehicle registration $2,000, and the new DWLS should be $500. We'll be asking for no driving order as well. She was picked up on this bench warrant for driving a license suspended, then committed another offense of the same nature. So we're asking for those bonds.
All right. As to the driving while license suspended, the bond would be set at, you said 2,500?
The bench warrant, yes, 2,500, yes, Your Honor.
Bench warrant.
Your Honor, the case number is C Quebec Echo,
Yes.
2,500.
Correct. As to the driving while license suspended,
Asked for 500.
Can you read the case numbers out, please?
Yes, I can. AJWDCQE.
Is the bench warrant that was 2,500.
This one's 500. Driving while license suspended
The new charge, which is
and driving while license suspended knowingly. The case number. It's a Florida Highway.
The 9 LE.
9 LE. Yes, we're asking, state's asking for 500.
500.
Yep. And then the last charge, which was bench warrant, it was Alpha Juliet Whiskey Delta Commander Sierra Echo. We were asking for 2,000 pursuant to the statute.
I'm not sure if I have already, Madam Clerk, are you looking at 4 or 3?
3.
I only have 3 myself.
Yes, so it was 2,000 on the registration, then 500, and then on the new DWS, and then 2,500 on the bench warrant from the DWS.
Okay, I apologize. I'm going to need it back because I didn't see the, sorry about that. Registration expired.
Yep.
That one received a $2,500 bond wrong, correct?
So I had asked for 2,000 on it. It was CQE. I'd asked for 2,500, but whatever, obviously.
2,000.
Yep.
As to the driving while license suspended knowingly,
Is the new charge is 500.
I got that correct. And
Then CQE, which is the old DWS bench warrant, 2,500. And then I would also be asking for you to issue what's known as a no drive order, basically telling the defendant she can't drive.
Your Honor, it's the defense's position that the $2,500 bond on one bench warrant, the $500 bond on the DWS is more than sufficient to ensure her appearance in court. There's no need to then impose an additional $2,000 or $2,500 bond on the third case.
Once again, the state will note that pursuant to the statute, it tracks with each count on these bench warrants.
It's my reading of the statute does not require the judge to issue this amount for each of the counts.
in this case,
Yes, he can issue the bench warrant amount for, okay, for Charlie Sierra Echo, what's the bond?
We had that as 2,000 pursuant to the statute.
as for 9 LE, it's now 500.
We
Nine.
have the 9 LE, we're only missing the Charlie Sierra Echo. The registration expired.
Right, so it was 2,000.
Correct.
Judge, could you announce the bonds, please?
Yes, one more time. Here we go. The case on AJWD CSE, $2,000. Case number AJW DCQE, $500. And case number let's see. I think I only have the, no, here it is. 9 LE, $500. All right.
Thank you, Your Honor.
Okay, no driving. You may not drive at any time, ma'am. Do we understand? Ms. Katani?
Yes, sir.
Issued an order indicating that next time the bonds, if this were to occur, will be more likely than not, I would be probably the judge in those, but they would be set very high. So please don't be doing anything that would negatively affect the current situation. All right? Good luck to you. Next case, Mario Lugo.
Your Honor, these are added charges.
Lugo what? I didn't hear that last part. Corrections, what?
These are added charges. He's been held on a felony already, not on F-25 9693.
Okay, thank you. Mr. Lugo, you've been charged with petty theft, misdemeanor of the second degree in violation of Florida statute 812.014 sub 3 sub A. State
Recommendation here is $1,000 bond. This defendant has least, by the way, printed on ours, 1, 2, 3 pages worth of priors, a number of them involving burglary of an unoccupied structure, previous petty theft convictions, grand theft. This defendant has a tendency to put his hands on things which are not his. We're asking for $1,000 and stay away order.
Your Honor, the defense in this case would be asking for a dollar bond. He's already being held on the felony as ordered by corrections.
State.
State would stand by the $1,000.
$1,000 bond it is. Thank you.
What was that, Your Honor? I'm sorry.
Yes, $1,000 bond will stand. Thank you. Next case. Jamal.
The stay away order, Your Honor. I passed it up, and can we get him
I
back?
didn't have this. Oh, here it is.
Yes.
Thank you.
Yes. Can we get him back?
Yes. I'm sorry, Madam Public Defender. There was a stay away order over to my left. I didn't see it.
We have Mr. Lugo, Your Honor.
Announce it, but I lowered it. Mr. Lugo, I've issued a stay away order in your case. You cannot return at any time to 599 West 49th Street, Miami Beach, Florida, the Old Navy location where you were arrested. All right? Good luck. Next case. Khalil Jamal Charles.
Stay away order here, Your Honor.
Good morning, sir. You've been charged with one count of misdemeanor exposure in violation of Florida Statute 800.03, sub 2, sub A. Taking a look at the arrest form. I find probable cause for the arrest. In this case, state.
That'll be asking for a $1,500 bond.
Judge, the defense would be asking for the standard bond here of $1,000 with the pretrial services in the alternate. He has no criminal priors.
State.
One moment. We can do $1,000 bond. State would recommend, state can go with $1,000 straight up bond, but not pretrial services.
$1,000 bond. No pretrial services at this time. I've entered a not guilty plea on his behalf. He must stay away at all times. Mr. Charles, from the location where this incident occurred, which was in the arrest form. I'll have to write it in. State Road 915.
Judge, the stay away order is from the street. He's alleged to have been driving at the time. Not sure.
Your Honor, I believe it should be for the victim there. There should be initials.
The victim, it says KC, and I apologize.
Yes.
In this case, I didn't see the name of the individual referenced in the report, but I guess.
Pursuant to Marcy's law, Your Honor.
Got it. The victim in question alleged, Mr. Charles, you'll have no contact with whatsoever. Stay away from her. Thank you. Next case, Leonel Abraham Cortez Contreras.
I do have a probable cause argument to make here, Your Honor, whenever you're ready.
Mr. Contreras, you've been charged with a misdemeanor of the first degree, resisting an officer without violence to his person in violation of Florida Statute 843.02.
Okay.
Thank you. Yes, ma'am. We'll hear from you, please.
Yes, Your Honor. In order for someone to be charged with resisting without violence, the officer needs to have legal duty. Here, Mr. Cortez was walking on the bridge when the officer was approaching him. He was off his bicycle. It's our position that there was no legal duty sufficient to support a resisting without violence, Your Honor. So we would be asking for him to be released outright. In the alternative, I don't see any criminal prior, so we are asking for an ROR.
State?
As for probable cause, the state will look towards the last sentence on the first page and it leads over on the second. Officer Resego observed a defendant operating an electric bicycle on the footbridge and walked towards the exit part of the bridge in full Miami Beach police motor uniform. Here, the defendant is operating the electric bicycle. The officer is the one doing the walking. And there's also a posted city sign saying that you can't be operating a bicycle on this bridge. So there is legal duty here. As for bond, one moment. State would be fine with the bond of $150 for pretrial services.
$150 bond, alternate pretrial services, correct?
So, excuse me, I should say pretrial services with an alternate bond of $150.
Got it. Good luck to you, sir. Thank you. Next case is Sherman Gilbert Anderson.
We do have to stay away here, Your Honor.
This was originally before Judge the Honorable Edward Newman. Bench warrant was issued for the arrest when he failed to appear. Yes, thank you. He's been charged with this case. Petty theft in violation of Florida Statute 812.0143A. And the original narrative. It was at a Walgreens, October 17, 2024, if I'm not mistaken.
That's correct.
Thank you. This time, does the state have an offer or alternatively a bond?
It'd be a bond of $2,000 pursuant to the statute.
Madam Defender?
Yes, Your Honor. It's the defense's decision that you're not required to issue a $2,000 bond. You can use your discretion. The bond amount that's already been set on the bench warrant is more than sufficient to ensure his appearance in court. As is indicated on the arrest form, Mr. Anderson is homeless. We understand that he failed to appear, but we're just asking you to keep the bench warrant amount as it is for his bond.
Your Honor, I can point back to the statute and say that any defendant who failed to appear on the day of any required court proceeding in the case at issue and who was later arrested shall not be eligible for a cognizant bond or for any form of bond which does not require a monetary undertaking or commitment equal to or greater than $2,000 or twice the value of the monetary commitment or undertaking of the original bond, whichever is greater.
State, can I have the statute that you're citing to?
Yes, it's statute 903.046.
What's the subsection?
Subset 2, subsection D.
Bond set $2,000. In this case, defendant shall stay away at all times from the Walgreens at 1845 Alton Road, Miami Beach, Florida, 33139. Good luck to you, sir. Next case. Osfani Garcia. Thank you. Osvani Garcia.
Stay away, we're here for you, Your Honor.
Good morning, sir. Mr. Garcia, at this time, you've been charged with a misdemeanor of the first degree trespass property after warning in violation of Florida Statute 810.091, subparagraph A, subparagraph 1, and a second count of resisting arrest without violence, municipal ordinance violation 10-10, Miami-Dade County Municipal Ordinance. I've read through the arrest form and I find as to count 1 and count 2 probable cause. Under the circumstances, the state have a recommended bond?
Yes, Your Honor. The defendant has 2 other open cases of the same type, M25-7897, which is trespass after warning, and M25-7975, which is trespass after warning, criminal mischief. We will be asking for a bond amount of $500 to the trespass and $250 on the resisting arrest.
Your Honor, the defense would be requesting for Mr. Garcia to be released on his own recognizance and given a date certain on the homeless calendar. I've confirmed with Mr. Garcia he is currently experiencing homelessness.
Any objection by the state?
Due to the Yes, due to the recency of these charges, they're all M25s. The state would be still sitting on $500 and $250 amounts.
Released on his own recognizance, granted. Homeless date, we have July 2nd, 2025 at room 6-7 at 9 a.m.
Your Honor, that's RR on both counts?
Yes, ROR on both counts. And I'm going to place that in the order here of the homeless calendar date of 7/2/2025. Courtroom 6-7 at 9 a.m.
And did we do the stay away order, Your Honor?
In this case, because he's being released on his own recognizance, Ms. Landerin, the court also finds it prudent to enter a stay away order. He may not return to the gas station at 7411 Southwest 8th Street, Miami, Florida 33144. Otherwise, he will be subjected to being potentially rearrested. Thank you. Good luck to you, sir. Next case. Be the case of Ernesto Juan Jimenez. Mr. Jimenez, you've been charged with a misdemeanor of the second degree, seeking to defraud an innkeeper in an amount less than $1,000, violation of Florida Statute 509.155, subsection 1. Court finds probable cause for the arrest and the charges set forth therein. State have an optional.
They would be asking for a bond of $1,000. This defendant has 2 open petty thefts as it stands, and 2 counts of petty thefts, I should say, in B25-6956. He's also been convicted as of May 13th, 4 days ago, convicted twice on defrauding an innkeeper. Also has another defrauding innkeeper. There's three defrauding innkeepers that were just closed out literally 4 days ago, and here we are. We'll be asking for a $1,000 bond.
Court enters the $1,000 bond at this time. At this time, Mr. Jimenez, you must stay away at all times from 9090 Southwest 97th Avenue, Miami, Florida 33176. And
Yes, sir.
it would be the
I can tell you. 9090 Southwest.
It is a restaurant.
Yes, it is a. Yes, it's a restaurant sometime.
Thank you. Good luck to you, sir. Thank you. Next case is the case of Travis Smith.
We can pass Mr. Smith, Your Honor.
Jefferson?
Right, we'll pass Mr. Smith for now. Alex Jefferson. Mr. Jefferson, you were picked up on a bench warrant. In this case, he was given a date previously by Judge Karen Schwartz on the homeless calendar and released ROR. Originally, he was charged with trespass to property after warning in violation of Florida statute 810.091A1. Under the circumstances, court finds probable cause.
Judge, the defense would be asking for a standard bond of $150 in the alternative program or TAP, given that Mr. Jefferson has been experiencing homelessness, Your Honor. I understand that he's failed to appear in the past, which is why I'm not asking for the homeless calendar, but at least he has the opportunity to be given a place at a shelter while he waits for this case to be resolved.
Any objection by the
The
state?
state would object again pursuant to the statute and this bench warrant. He was given a date certain. He was told to be there in person and was not. Furthermore, the defendant has a long history of priors, or a number of priors, I should say, and thus we will be standing by on that $2,000 pursuant to the statute.
His last prior was 6 years ago, Your Honor.
Thank you. At this time, the bond will be set at $150, and the stay away order is going to be issued by the court. You'll stay away from Brickell City Center at 701 South Miami Avenue, Miami, Florida 33130. If he is found there again in that location, he subjects himself to arrest. Good luck to you, sir. Next case, the case of Antoine Maurice Elvin. Mr. Elvin, you've been charged with a first-degree misdemeanor of trespass of property after warning, 810.091A1. There's a Walgreens located at 15900 Northwest 27th Avenue, Miami Gardens.
Yes, sir.
Court finds probable cause. In this case, the state.
We can ROR here, Your Honor.
This is going to be ROR. In this case, Mr. Elvin, you're
Yes,
not
sir.
back to the Walgreens at 15900 Northwest 27th Avenue, Miami Gardens, Florida 33105.
Understood, sir.
You're going to be released on your own recognizance. Good luck to you, sir. I've entered a not guilty plea on your behalf. Will, I presume, then be receiving notification?
An address, Your Honor.
Mr. Elvine, you have an address.
Yes, yes, sir.
Does he receive mail there?
And you receive your mail at that address, yes?
Yes, sir.
Good. You'll be getting notice at that address, sir. Thank you.
Thank you, sir. Have a great day.
Next case is the case of Mark Anthony Cooper. Mr. Cooper, in this case, you've been charged with a second-degree misdemeanor of petty theft in violation of Florida Statute 812-0143A. This is a Walmart located at 17650 Northwest 2nd Avenue. Court finds probable cause. State.
Yep. State will be asking for a bond of $750 here. Defendant has a number of priors that are theft related in his past, including petty thefts as recently as 2020 and 2022.
Bond set at $750. Probable cause found.
Your Honor, the defense is requesting a pretrial services in the alternate.
Any objection by the state?
No objection.
I was about to say, the silence is deafening.
Yes, Your Honor.
Ergo.
It takes me minutes
It's
sometimes, Your Honor.
okay. And by the way, it's hard to read they're very small print. You know, we're
Yeah.
saving paper, but at the same time, it's hard to read that in such a quick manner. Alternate bond set at 750, pretrial services eligible granted. And a stay away order at no time, sir, may you return to the Walmart at 17650 Northwest Second Avenue, Miami Gardens, Florida. Good luck to you. Next case. Case of Michael Giuffre.
He
Yeah,
refused, Your
defendant
Honor.
in court. He also has a hold for immigration, reset for tomorrow.
Reset. Yes, sorry. Next case will be the case of Stephen Hale.
Your Honor, I do have a probable cause argument to make here.
You. Mr. Hale, you've been charged with a violation of a misdemeanor of the first degree, criminal mischief, more than 200 but less than 1,000 in violation of Florida statute 806.13. Also, a misdemeanor in the first degree of indecent exposure. That would be a violation alleged to be of chapter 800.032A. And give me a moment to read the arrest form, please. Yes, ma'am.
Yes, Your Honor. Specifically in this case, we would be requesting for Mr. Hale to be given a date certain and released to the homeless calendar. I did confirm that he is currently experiencing homelessness as is indicated on the arrest form. And then the probable cause argument that I'd like to make would be specifically with reference to the indecent exposure charge. While I understand the nature of the allegations referenced in the arrest form must allege behavior that is lewd and lascivious, which would require some kind of sexual nature. The exposure of genitals is not enough to sustain probable cause for an indecent exposure. And specifically, the officer would have had to allege something of a lewd and lascivious nature, such as the defendant being aroused or something that would indicate lewd and lascivious. Here, the mere exposure is not sufficient to support probable cause for indecent exposure. And nonetheless, he does not have any lengthy priors in this case, and we're asking for him to be released to the homeless calendar.
Reply, state.
Your Honor, I will just point to the third full paragraph on the page, and I'll just read it. Officer Elia made contact with the library manager who revealed surveillance footage and confirmed that the subject was captured on video striking the police vehicle with his right elbow. Mr. Capley also showed the footage of the subject lowering his shorts, exposing his penis, and twirling it in circular motions directly in front of the library where numerous pedestrians, including families with children, were present. Your Honor, that is lewd and lascivious.
At this time, the request by the public defender is denied. At this time, is there an offer of bond?
We would be asking for a standard bond on criminal mischief of $500, and due to the facts of the case, we'll be asking for $2,000 on the indecent exposure.
Can he also be set on the homeless calendar for that or no? Are they consistent, those two.
I mean, if he were to pay bond somehow, and then he could also be given a date certain, sure.
Thank you. I'm going to grant the request by the public defender to set him on the homeless calendar. And the date for that would be July 2nd, 2025, courtroom 6-7 at 9 a.m.
So will he be released, or is Your Honor?
Your Honor, is that an R on both counts?
ROR, my apologies, I misspoke. So it's one or the other.
Well, I apologize. I didn't realize he was going to be ROR'd on his own recognizance in that regard. That's what that was the premise of my question earlier. As to the criminal mischief, count 1, the bond is set at $500. Count 2, $2,000.
Can he be given TAP in the alternative, Your Honor, so that he could potentially be released to a shelter if a bed becomes available?
Any objection by the state?
No objection to that, Your Honor.
That program approved. Say again? Yes, same bond amounts on both counts. Thank you. Next case, the case of Mario Luis Savon.
Oh,
Is there a stay away order on Mr. Hale?
realized I forgot.
And before Mr. Hale leaves, we have a stay away order. He must at all times stay away from the Miami Beach Public Library, 227 22nd Street, Miami Beach, Florida. He's free. Your question was, I apologize.
Your Honor,
Go ahead.
We answered it. Mario Savon,
Your Honor, resent for tomorrow medical.
thank you.
Mr. Chirino?
Sí.
Mr. Chirino is present before the court, Your Honor. He will require the Spanish interpreter.
Your Honor, Mr. Torino is also a VFox.
I'm sorry, and this is Mr. Chirino? Madam Public Defender.
Yes, this is Mr. Chirino, and he'll require the use of the Spanish interpreter.
Got it, thank you.
Very good. Sir, you've been charged with a misdemeanor of the first degree battery in violation of 784.03 Florida statutes.
Señor, usted enfrenta un cargo por agresión física, delito menor en quebrantamiento del estatuto 784.3.
Court finds probable cause. In this case,
You can give me just one moment, Your Honor.
Este despacho halla que si hay motivo fundado para el arresto. Un momento.
Looking into the violent felony offender special concern here.
El juez está revisando el informe en de ser reinfractor incidente de alta peligrosidad.
Trying to figure out if battery is could be one of the charges, which would mean that he is not eligible for bond. But I'm going to need just 1 second.
Un momentico, dice el juez, estoy revisando para asegurarme que el cargo de agresión física conlleve o no fianza. Un momento.
Your Honor, he's on probation F24 20355.
Señoría, él está en libertad probatoria en un caso del 2024.
Given that he's on probation, Your Honor, the defense would be requesting a dollar bond on this case, and then Your Honor could place a felony hold so that the felony judge will address the probation hold.
Señoría, dado que él está en libertad condicional, estamos pidiendo que le den una fianza de $1 para que el juez del delito grave pueda abordar el caso del delito grave, el delito mayor.
Due to the facts of this case, the state would be asking for and the fact the defendant is a violent felon of special concern, state will be asking for a bond of $4,500.
Señoría, dado que este es un infractor reincidente de alta peligrosidad y dado los hechos del caso, estamos pidiendo una fianza elevada de $4,500.
$4,500 bond set in this case.
Se fija la fianza a $4,500.
There will be a stay away order. Mr. Chirino may not return and be within 500 feet at any time, if he is to be released, with respect to the alleged victim, Monica Bailey.
Tendrá que mantenerse por lo menos a 500 pies de distancia de la presunta víctima, Mónica. Your Honor, for the last name, what's the last names of the alleged victim, please?
Bailey, B-A-I.
Got it. Thank you, Judge. De Mónica Bailey, por lo menos a 500 pies.
Good luck to you, sir.
Your Honor, you placing a hold on the felony case?
Yes, 1 second. And the hold for the felony case. Thank you. Corrections. Thank you. Next case, Michael Jessier.
Stay away order, Your Honor.
Thank you. Mr. Jessier, you've been charged with a misdemeanor of the first degree trespass of property after warning in violation of Florida Statute 810.091A1. Finds probable cause in this case for the arrest. The state has a bond, yes or no?
We can no bond here, Your Honor.
No bond required, released on his own recognizance?
Yes, Your Honor.
In this case, Mr. Jessier, you may not return to the Gale Miami Hotel at any time until further order of this court. The location of that hotel, as you know, is 601 Northeast First Avenue, Miami, Florida, 33132. I've entered a not guilty plea on your behalf, and you'll be released later today, I believe.
Right. Okay.
Good luck to you, Your Honor. Next case, George Louis Bedstard Celes.
Your Honor, so that was a RR for Mr. Jessier?
Yes, yes. We have two cases for Mr. Bedstard Celes. The case number that I'm going to call first ends in 8.
Can we pass him, please? He's coming from forensics.
So pass. Okay. We'll put them to the end of the calendar and see if he makes it. We're also still holding for Travis Smith, but I'll set.
Mr. Bedstard is here, Your Honor.
And Mr. Smith gonna be next.
And Mr. Smith will be next.
Yes, ma'am. Smith will be next. And who has just arrived, Mr. Bedstard Celes?
Correct.
He's got 2 counts against him. One, misdemeanor first degree of being in possession of drug paraphernalia with the intent to use in violation of 893.147. That's the case that ends in the following numbers, 8084. Apparently, he must have been picked up on a warrant for that case. The second case, petty theft, misdemeanor of the first degree, charged in violation of Florida Statute 812.0142F. That case number ends in 6316. Take the first case, 8084 first. What's the offer, if any, by the state?
Will be, give me 1 second. I want to check this bench warrant. E25, 8084. Inform was issued 430. State would be asking for the $2,000 bond there. And to this new petty theft, state would be asking for a bond of $500. We've seen that the defendant won't show up to court.
For the benefit of both the state and the public defender, I have found probable cause as to both charges. Any reply or response, Ms. Lander?
Yes, Your Honor. Specifically to the case ending in 8084, this is the drug paraphernalia case. I know Your Honor just said that you found probable cause there, but for drug paraphernalia with intent to use, there needs to be some indicia of drugs. There's more than just the drug paraphernalia, which could be residue found or drugs found at or near the proximity of this person when they're arrested. That's not alleged in the arrest form here. I understand that if a bench warrant was issued, that Your Honor will set the standard bond. But with respect to case ending in 6316, the petty theft, there has been no value alleged for the amount that he's accused of taking. So this should be at best a second-degree misdemeanor. And given that he will already be held on the $2,000 bond for the drug paraphernalia, we'd ask for a dollar bond on the petty theft.
Pulling up the A form for the petty theft now. No. So as to the drug paraphernalia, I'll stand by on the $2,000. And the petty theft, 2 cases, beer, Tide Pods, something got walked out. Yeah. On that one, we may have to ROR.
Say again.
We'll have to ROR on that one.
ROR with respect to case number ending 6316. With respect to the
Actually, Your Honor, I should clarify. The state would agree that there is not the value necessary for the charge, and that there is no that he would be released outright, not released on his own regard.
Are you null crossing the case?
No, I'm not null crossing it at this time.
Judge, and I would also like to point out, Mr. Bastard has just indicated to me that the date the bench warrant was issued, he was in custody on April 30th. I don't know if that's something the state can confirm or deny right now, but he's saying that he was in custody. That's why he failed to appear.
Yes, he's been in custody since April 30th.
Then that is not willful. We'd still be asking for a bond of $500 in that case.
Given the probable cause arguments that I've made to Your Honor, I would ask for him to be released either outright if Your Honor finds no PC, or at least to the homeless calendar.
In this case, it would also be a felony hold here because he has no felony charge.
These are added charges.
Gotcha. Okay.
And a dollar bond, Your Honor, given that he's held on other charges.
Would that be with case number 8084?
Correct, Your Honor.
Any objection by the state?
Again, clear glass pipe. Your Honor, I argue that there is probable cause for the drug paraphernalia. Clear glass pipe with burnt residue suspected to be crack cocaine was in plain view on the driver's seat. And then he was also, just give me 1 second. So I would argue that there is PC based on the fact they believe it's crack cocaine, and they charged him with controlled substance possession of crack cocaine. So there is probable cause there, which would stand by on my argument for at least a $500 bond on the drug paraphernalia charge, considering he already has an open drug yes, he also has another open drug paraphernalia charge.
I concur. At this time, $500 bond as to case ending in 8084, and ROR as to case number 6316, correct?
Yes, Your Honor. And he still has we'd be asking for the felony hold on F25.
Felony hold, these are added charges.
Charges, my apologies, corrections.
Thank you. Next case, Travis Smith. Good morning, Mr. Smith. In this case, you've been charged with trespass to property after warning, first degree misdemeanor in violation of Florida statute 810.091A1. This occurred at City Center Doral. It's alleged that there had been observations related to a theft and trespass to property. I find probable cause. In this case, the state.
Your Honor, we'd be asking for an elevated bond of $1,000 here. This defendant has 5 convictions for trespass after warning and is currently facing 6 open cases for trespasses. And thus, clearly, there's something not clicking about not going where you're not supposed to be.
In this case, bond set at $1,000. Stay away order. Mr. Smith, you may not return to City Place Doral at 8300 Northwest 36th Street, Doral, Florida, 33122, or you subject yourself to being arrested. Good luck, sir. Thank you. Next case. Case of Jaime Londano.
Your Honor, reset for tomorrow. He was relocated to Metro West.
Thank you. And Madam Clerk, he had several different cases. You want me to put that on all of them or just one of them?
Just on the-
This happened before as well.
Right, you can put it in the same area.
Okay, let me see if I.
You know, on the traffic, reset, put on the traffic as well, Chad.
I will.
Thank you.
I'm not sure exactly, but he's in Metro West, right? One. And I put it,
You can put it right down, like where the line's at, right down. Right.
next case would be the case of William Frederick Lominack.
Your Honor, I have arguments to make on this case whenever you're ready.
He's been charged with a misdemeanor of the first degree, providing a false name after his arrest in violation of Florida statute 901.36 sub 1. And there was a warrant issued for his arrest outstanding at the time. Yes, ma'am.
First, Your Honor, as is indicated on the arrest form, Mr. Lominack is currently experiencing homelessness. There's no indication as to whether this was a willful failure to appear, whether he even received notice of this court date for the no valid driver's license, which I will also say is a traffic offense and not a serious offense. And further, Your Honor, it's unclear why Mr. Lominack was arrested to begin with, given that he's only been charged with false name after arrest. While I understand he was picked up on the warrant, in order for there to be probable cause for false name after arrest, there needs to have been a valid arrest to begin with. And here, there's nothing indicating why he was being detained to begin with.
Response.
Also, Mr. Lominack has a related felony. He'll be coming back on your bond hearing calendar.
I believe. So here, they were investigating an unrelated case, PD 20250516143627. That PD case number, I can give one moment here and double check before I make a statement. F259962. That PD case number would, I can get this to cooperate, 627. 627. Yeah, the PD case number tracks to the same case number as the felony arrest here. So the false name was given after during the investigation of the burglary charge that he's currently facing. So there is probable cause for that there.
Understood.
As to the traffic here, Your Honor, in that file that you have for the traffic, does it indicate who the bond judge was?
Correa.
Was Judge Correa? Okay. And
In that case, they issued a $10,000 bench.
bench warrant. Okay. There, I can't stipulate to there not being notice, but because he was, because of the new charges being picked up and everything else, the state would be asking for a $1,500 bond, actually a $2,000 bond on this false name charge, and then because he was facing the other charge, we'll ask for a $1,000 bond on the traffic.
One, did you say 1,000?
Yes, 1,000 on the traffic.
We have one count, as I said earlier, for false name after arrest. They're seeking a $1,000 bond. Granted. As to the traffic violation, the bench warrant was executed in essence. That's why he's here.
Yeah.
So you're seeking.
What was the bench warrant amount from?
Originally $10,000.
State would be asking for 2,000.
Bond set at $2,000. And there's a felony hold, as I understand.
Yes, Your Honor, we'll be addressing that later.
It'll be later on our calendar. Good luck to you, sir. Thank you. Next case would be the case of Halsley Miguel Durand. Mr. Durand's been charged with a municipal ordinance violation, open container in a vehicle, violation of County Ordinance 30-21001A. He was picked up on a warrant, which was issued, and that was related to the case. Let's see. Well, he has a no driver's license ticket as well, AL9Z2CE. Let's see, no valid license and failed to establish residency in the state, and no registration, it appears. All right, so with the case involving the open container.
As to the open container, due to the facts of the case, because the defendant was already facing an DDL, we'll be asking for a $500 bond. He's clearly driving, according to this A form, with no valid driver's license and has an open container in the car.
Judge, if I may,
You may.
Mr. Durand is indicating to me that he does have a valid Pennsylvania driver's license. This is, I think that this is probably something he showed the officer, given that he wasn't cited again for no valid driver's license.
Exactly.
Further, I think that the standard bond for a local ordinance, the bond should be at most $150, Your Honor, in addition to the bench warrant amount.
Okay. Bond is set at $150 for the open container. Historically, councils, they usually allow a party to come forth with a valid driver's license, and that can, unless there's an extensive history of not having one,
yes,
result in a null process.
Yes, Your Honor. I had run the local Florida. I'm not aware of, I don't have a way to check for a Pennsylvania driver's license. I was operating off the local Florida and the previous. As for the other charge or the bench warrants, they'd be asking for that $2,000 required by statute.
Denied at this time. Men are not guilty. He does reside here in Dade County.
He does live here, Your Honor, at the address that's in the arrest warrant.
Good. If he's eligible to be released, he'll get notice there for his upcoming hearing regarding the open container. I've entered a not guilty plea on his behalf. As to the bench warrant amount of 500, there's no need for that anymore. It's quashed, yes?
State would be asking for the 500 to be held.
He's got a $500. I'm sorry, I gave him a $150 bond.
Bond on the open container,
I don't know of any other charges to you.
the bench warrant, I'd just be asking.
Well, he had no valid license at the time, but he's about to show us one, we think.
Oh, I will say that it would require a court date before we can do anything about that. The out of
Okay,
state.
I'm going to set aside the bench warrant that's outstanding if it hasn't already been done so by virtue of him being picked up on it, all right? Thank you.
I'm sorry, Yana, what's the disposition on the traffic case?
The traffic case is still active, but I'm vacating any bench warrants that are related to it at this time. Second, so he doesn't get picked up on that again. And then he has
Is
a one,
RR on the traffic case?
the open container in the vehicle municipal ordinance case is a $150 bond.
Your Honor, when the gentleman came into custody, the bench warrant was already vacated.
Right.
You have to address the bond. You're gonna give him a RR or you're gonna give him a bond?
We would ask for the $500 bond, all things considered, but
ROR granted. Thank you.
Thank you.
How about Milton Omar Godinez Vasquez?
Mr. Godinez will require the use of the Spanish interpreter, Your Honor.
Got it, thank you.
Thank you. Mr. Godinez, you've been charged with numerous counts, misdemeanor of the first degree resisting an officer without violence, violation of Florida statute 843.02. Mr. Interpreter.
Señor Godínez, usted enfrenta varios cargos. Tiene uno que es por delito menor en primer grado, es por resistirse a un oficial sin violencia, en quebrantamiento del estatuto 843. Your Honor, was it 843.0? Got it, thank you, Judge. 843.02, thank you, Judge.
Thank you. A misdemeanor of the first degree, providing a false name after arrest in violation of 90136.
También por un delito menor en primer grado, por proporcionar un nombre falso después del arresto en quebrantamiento del estatuto 90136.
Your Honor, Mr. Godinez is also held on a probation warrant F19-10895.
Dice el departamento carcelario, señoría, también él está de hecho retenido por una orden por quebrantar la libertad probatoria, tiene una orden de arresto en un caso del 2019.
Thank you. He had a third charge in violation of Florida statute 322.03, no valid license.
También tiene otro cargo en quebrantamiento del estatuto 322.0 algo por no tener licencia válida para conducir.
Lastly, a violation of Florida statute 322.34, driving while license suspended after a second subsequent conviction.
Y también otro quebrantamiento del estatuto de la Florida 322.34, que es manejar con la licencia suspendida después de tener un segundo fallo condenatorio por el mismo.
So, how would the state like to proceed?
so here, Your Honor, the state would be asking for $500 bond on the second subsequent conviction of the DWS. We would be asking for a $500 bond on the NVDL. We'd be asking for 500 on the RWAV. We'd be asking for another 500 on the false name. This all due to the fact he's got that probation warrant that will be have to be handled later because it's a felony.
One second, state, please. It's okay. Señoría, estamos pidiendo entonces por una fianza estándar de $500 para el cargo de manejar con licencia suspendida después de tener un fallo condenatorio. También $500 de fianza por el cargo de manejar sin una licencia válida. $500 de fianza también por proporcionar un nombre falso. Y todo esto lo pedimos por... You may continue, State. Thank you.
Thank you. It would follow that he gave this false name, gave this resistance because that probation warrant existed.
Él, de hecho, dio este nombre falso y se resistió debido a que justamente ya estaba la orden de arresto vigente.
And further, these are also traffic cases when we've already seen this defendant act irresponsibly on the road.
Y de hecho, ya hemos visto a este acusado en el pasado actuar de manera irresponsable en las carreteras.
I may be heard, Your Honor.
Señoría, si me permite.
And for the purposes of the arguments made by the state and the court's review of the A form, the court hereby does find probable cause as to all 4 counts. Yes, ma'am.
Yes.
En cuanto a... One second, counsel, please. En cuanto, dado los argumentos que presenta la fiscalía y los hechos que se dicen en el informe del arresto, este despacho halla que hay motivo fundado para el arresto. Go ahead, counsel. Sorry, but I needed to interpret that.
No need to apologize.
Thank you.
With respect to the false name after arrest, Your Honor, we have no objections to the $500 bond on that count. However, don't believe that it's necessary to issue a bond on each of the counts, specifically for count 1, resisting officer without violence.
Just one second. Señoría, no objetamos en lo que tiene que ver con los $500 de fianza por proporcionar un nombre falso después del arresto, pero no creo que sea necesario darle la fianza para cada uno de los otros cargos. Y me continue, counsel.
It seems that he's been overcharged. There's no resisting without violence here. If they're trying to allege that the resisting is also the false name, then the false name, a bond on the false name after arrest is sufficient. There's nothing in the A form to indicate a resisting.
Dice la abogada, señoría, no hay nada realmente que indique que él se resistió, aparte de dar un nombre falso.
Additionally, he's been charged with driving while license suspended and no valid driver's license. Either he's had a license in the past or he hasn't, but these charges are duplicitous in that there should only be one or the other. He could never be convicted of both because, again, either he had a license that is suspended or he never had a valid driver's license. So we're
Aparte de
asking,
todo, la defensa está pidiendo presentando el argumento de que o tiene licencia suspendida o simplemente no tiene licencia, pero que no pueden ser ambos.
we're asking for the $500 bond on the false name and then the standard, either a $150 or $500 bond on one of the traffic offenses.
Y estamos pidiendo que sea solamente la fianza estándar en el dar el nombre falso, perdón, la fianza de 500, o bien sea la fianza estándar de 150 o 500 para solamente uno de los otros.
The state would be willing to do $500 on the false name and $500 on the DWS.
La fiscalía está dispuesta a que se le dé fianza solamente de $500 en el del nombre falso y el de $500 en el state for the interpreter, 500 on the false name and 500 on the other one. Was it, counsel, please?
Driving while license suspended.
Got it, thank you. Por el de manejar con licencia suspendida.
Court finds reasonable grounds for the entry of the bond on false name 500. That would be count 2. And with respect to the driving while license suspended 500 on count 4.
Entonces este despacho halla que hay motivo fundado para que se justifica la fianza de $500 para el cargo número 2, que es dar el nombre falso, y $500 para el cargo número 4, que es el de manejar con sin licencia, perdón.
As to count 1 and count 3, ROR.
Y libertad bajo palabra para el primero y el tercer cargo.
Good luck to all of you. Thank you.
Buena suerte para todos.
Next case, these are some add-ons, as I understand. No?
This only has 2 counts, so it's only on this misdemeanor, count 1 and count 2. All right, and stretch that out.
1 second. Because they were dealing with 4 counts.
No. This is a misdemeanor. This is just not this. So I have to do a separate.
Thank you.
You're welcome. So let's X that out.
Okay. So the record's clear. Before he runs away, well, you can write. Mr. Rivas, count 3 that I referenced, ROR, I'm striking out because it's not part of this. And the rest stand?
Yes.
Thank you. No, that was the driving while license
It's
suspended.
gonna be on here.
Got it. So as to count 4, where we issued a $500 bond, that's coming off as well because we're gonna issue the bond on the actual traffic form. My initials right there. Thank you so much. Okay. And we should proceed with the
It's
add-ons.
on a bond on the traffic
Just,
and what about this time? We want those rest. What are we going on?
no bond. No bond. That would have been on the 3rd. Do you need the ticket number?
No, Judge, I haven't.
You have it. Good.
Thank you.
Is this related to which one of the traffics?
Right here. Let me show you. This is the, right here.
Okay.
And this is the,
This would be related for the state's purposes, knowingly violation of driving while license suspended.
the what they bought.
And they're indicating I don't have that option, so we'll make it a $150 bond as well. Thank you, Sergeant. Okay. Frankie Jr.,
I'm sorry, Your Honor. Did you change bonds on Mr. Godinez?
I did.
For the rest, Judge.
I'll read it for the record. Sorry about that. As to case number ALIAGCE, $500 bonds.
So he's no longer RR?
No corrections on the misdemeanor, count 1 and count 2 is ROR.
Count 1 is ROR, count 2 is $500 on the misdemeanor. As to the well, these are misdemeanors as well, but they're traffic related. ALIAGCE is set at $500 bonds. And as to ALIAIME is $150 bond. Okay, we have some add-ons here. Frankie Jr. McKelvey. Mr. McKelvey's at the podium.
No, Your Honor, this is Mr. Castro. I don't know who. Yes.
I'm
Okay.
sorry, Your Honor. Who did you ask for?
Well, let's do this. The add-ons were put in front of Mr. Castro, who's now, let me take him.
Okay.
Mr. Castro starts with driving while expired for more than 6 months.
Case number you're on?
Case number ALI 9QME. The defendant is Oscar Kanaka Castro, or Castro Kanaka.
Your Honor, he has a related felony. He'll be back on your bond hearing calendar. Also, he has a hold for immigration.
He'll require the use of the Spanish interpreter as well.
Could I have the, please? Corrections, could I have that felony case number, please?
F25 99009.
Thank you.
You're welcome.
Okay. So for purposes of the case that he's before the court today on, which would be ticket number ALI 9QME, I find probable cause. He was driving at the time alleged under a driver's license expired for more than 6 months, and quite frankly, it was revoked in 2007 for habitual driver.
Bueno, hallo, dice el juez, el motivo fundado para el cargo de manejar sin esta licencia, resulta que ya había sido la licencia revocada en el 2007 y para el momento en que lo detuvieron ya la licencia había vencido por hacía más de 6 meses, desde hacía más de 6 meses.
Thank you. At this time, does the state have a bond amount?
State would be asking for a bond of $500.
La fiscalía está pidiendo por una fianza de $500.
$500 bond. I understand he's going to be back on our felony calendar.
Yes, Your Honor.
And there's an immigration hold. Does the clerk want to put your immigration hold at the bottom? No? Thank you.
Entonces se le impone una fianza de $500, va a regresar al calendario de delitos mayores y tiene una orden de retención de inmigración.
These add-ons, we were asking if Mr. Frankie McKelvey had arrived and Michael Simmons.
They're here, Your Honor.
Let's call Frankie McKelvey right now, please, if you don't mind. He's an add-on.
Okay. And what's the case number? Oh, you did, I think. I'm sorry. Yeah, there it is. Thank you.
Apparently he was picked up, Mr. McKelvey was picked up on a bench warrant issued previously by the division judge. And he was sentenced to 6 months probation, adjudicated guilty. I can't tell the rest from the handwriting, but that's my fault.
Your Honor, these are added charges, Mr. McKelvey.
Yes.
On yesterday on F-25 4033 Alpha and F-25 2802. He was granted RR on both cases. He was getting ready to be released and these two bench warrants popped up.
Your Honor, state would be asking.
Both of them deal with drug paraphernalia.
Yep. State's going to be asking for a bond to $2,500 here pursuant to statute 903.046. He picked up those felonies while out on these bench warrants.
Which case?
State, these bench warrants, he was granted RR on these felonies yesterday when he was getting ready to be released from custody. These two bench warrants popped up.
That's exactly. So the bench warrants would still hold. The bench warrant here, while he was ROR on the felonies, these bench warrants were ignored by the defendant. He ignored court dates, and the statute dictates that it's $2,000 bond.
If I may, Your Honor.
You may.
This, Mr. McKelvey was in custody already. These bench warrants were discovered when he was being released from custody, but these bench warrants would have and should have already been vacated and served, given that Mr. McKelvey was already in custody.
I see that now, counsel. You are right. And so we can clear this.
I confirmed with Mr. McKelvey. He's currently experiencing homelessness, Your Honor, so we'd be asking for a date certain on the homeless calendar.
Okay. Any
felonies were ROR'd. We would no objection.
The homeless calendar is approved. He'll be back on July 2nd, 2025, courtroom 6-7 at 9 a.m. Make sure you arrive, Mr. McKelvey, on time. That would be as to case 2444, ending in 244. Same as to case. Well, let's see, this would be a.
So, Your Honor, you RR him on both cases?
When they're on the homeless state calendar, is it an ROR or no?
It's an ROR, yes.
Thank you.
An ROR with the date certain.
Yes, ROR. And we have another case, it's M24027010. He's been charged in that case with possession of drug paraphernalia in violation of 893.147 ROR. Again, he'll be placed on the homeless calendar. 7/2/2025, courtroom 6-7 at 9 a.m. Good luck to you, Mr. McKelvey. Next case, Michael Simmons.
Your Honor, on yesterday, Mr. Simmons, he was granted house arrest. When he was
Okay.
getting ready to be released on house arrest, this bench warrant popped up.
Same arguments, I presume, everyone. In this case, however, he was charged with count 1 violation of uniform voting citation, speeding in a manatee zone.
Yes, Your Honor, I just want to check the bench warrant date on this to make sure he was in custody.
Nonetheless, Your Honor, even if he wasn't in custody, the fact that he was in custody meant that the bench warrant should have been vacated when he was picked up on it. We're asking for an ROR.
But the bond would still need to be set on the bench warrant. So he was in custody for 3/2024. 4/7/9/36. His bench warrant was issued 11/7/2024. He picked up that felony while out on this bench warrant. We'd be asking for $3,000.
Your Honor, we'd be asking for an ROR, and if not, for Your Honor to match the release conditions that he was given on the felony, which in this case was house arrest.
Your Honor, the bench warrant was issued on 11/7/2024. He's been in custody since 4/3/2024.
So the bench warrant should have been cleared when he came in, and then bond to be addressed.
Credit time served, gentlemen.
He was in custody, I believe, when the bench warrant was issued in November. He's been in custody since April.
We can ROR on this.
ROR. Declined my offer on credit time served, Mr. Simmons, but you will be released today. Good luck. Next case. Omar Delgado Montserrat, alias Delgado Montserrat. I said that correctly.
Your Honor, he has a hold for Hendry County. No bond. He also has a hold for the Department of Corrections. Release date 5/20/25.
Who is this, Your Honor? I'm sorry.
This would be Elias Omar Delgado Montserrat, or it may be Omar Montserrat Elias.
Get a case number, Your Honor.
The case number is AFY 4T2E, no valid license. That's, yes. He was picked up, I guess, if he's with us, there he is, for a $1,000 bench warrant issued by Judge Capote.
Back in
Morning, Your Honor.
Good morning.
State would be asking for the $2,000 pursuant to the statute.
Bond set at $2,000, and he's on hold for Henry County as well corrections. Next case, case of Victorious Alzola, A-L-O-Z-A, Olaza, first name Manuel. So Manuel Aloza.
Case number, Your Honor.
This case number is AL99MOE, and then there's, I believe, maybe a new case number. Again, no valid license. And that would be, I only have the police department case number, I think. You need that?
Manuel Victorious, Your Honor?
Correct.
Yes, we've got it.
Mr. Victorious will use the Spanish interpreter, Your Honor.
Thank you.
Got it. Thank you.
Any offer by the state?
Judge, we'd stipulate to releasing the defendant on his own recognizance.
All right. In this case, he's released on his own recognizance.
La fiscalía no se opone a que le den libertad bajo palabra.
And that will be as to case AL99MOE. Do you have the other case? PD number 2505 516143905.
Your
It's the
Honor,
same case, Your Honor.
Your Honor, we only have one case for
Here we go. I think I've entered it accordingly. He'll be released today. Good luck, sir.
Ok, señor, entonces usted será puesto en libertad más tarde, el día de hoy. Buena suerte.
that was the RR, Your Honor.
Yes.
Thank you.
Ya, le conceden libertad bajo palabra.
The next case is Tommy Conyers.
Mr. Conyers is also held on a fugitive from Broward County. Total bond is $1,640.
Given the fugitive warrant and the bond amount, Your Honor, we'd just be asking for a dollar bond.
Okay.
Moment, Your Honor. Moment, Judge. Yeah. Judge, we'd be asking for a $4,000 amount here. There was a previous bench warrant for $3,000 in this case.
So the amount is how much? I apologize.
We'd be asking for $4,000.
$4,000 bond set. Good luck to you, sir. Thank you. He's being held on the fugitive warrant as well from Broward County. The next case would be the case of Juan Carlos Cruz.
I'm sorry, Your Honor, what was the bond amount for Mr. Conyers?
$4,000. All right, we have Juan Carlos Cruz. Alleged to be driving under the influence and causing personal injury and property damage.
Mr. Cruz will require the use of the Spanish interpreter, Your Honor.
Got it.
En caso de que no entienda algo.
Sí, va a ser en español.
Mr. Cruz, you've been charged with 2 counts. 1, driving under the influence in violation of Florida Statute 316.193.
Señor Cruz está enfrentado a 2 cargos. El primero tiene que ver con conducir o manejar bajo los efectos en quebrantamiento del estado de la Florida 316.913.
Also, driving under the influence, causing damage to property and persons in violation of 316.193, subsection 3.
Y también manejar bajo los efectos, ocasionando daño a propiedad y a personas en quebrantamiento del estatuto 316.913, subsección número 3.
State, you have an offer with respect to a bond in the case of Mr. Cruz.
El juez le pregunta a la fiscalía si tiene alguna oferta en cuanto a fianza para el señor Cruz. Go ahead, State. I'm sorry, I didn't mean to cut you off.
Okay, the case ending in JR3E.
Yes, Judge. The state would be requesting a $1,000 bond per count to the DUI damage property and then the DUI count.
En cuanto al cargo el caso que termina en JR, la fiscalía dice, sí, señoría, pedimos $1,000 de fianza para el primer cargo y $1,000 de fianza para el de manejar bajo los efectos.
And I apologize. If it's just the JRE, it'd be 1,000. In the case ending in DME, it'd be 1,000.
Entonces,
1,000.
Thank you. They're seeking 1,000 on both, on each count. I'm going to request, I do find probable cause based on the narrative set forth in the ticket.
dice el juez, si hay motivo fundado, están confirmando que sí son $1,000 de fianza para cada uno de los cargos y a la luz de lo que aparece en el informe del arresto, se haya motivo fundado.
As Spartan as the narrative was, and also that he refused to blow at the scene.
Y también dado que se rehusó a soplar en el dispositivo ahí en el lugar de los hechos.
Judge, the defense would be requesting pretrial services in the alternate.
Let's
La
ask him.
defensa está pidiendo el servicio previo al juicio como alternativa.
No objection, Judge.
La fiscalía no objeta.
So this will be an alternate bond.
Entonces, la fianza es una alternativa.
Assuming he's eligible.
Pretrial alternate 1,000 on both cases.
Yes.
Entonces, servicio previo al juicio como alternativa a $1,000 de fianza para ambos cargos.
And if I'm not mistaken, the last case for this morning's calendar is the case of Kendi St. Felix. Kendi St. Felix. Is Mr. St. Felix present? Mr. Cruz is free to step from the podium. Thank you. All right, Mr. Felix, good afternoon. We have one charge of failing to change their address or on the registration of the vehicle within 30 days. Violation of right, find it. We have the statute number, state.
Yes, Judge, I can get that for you. It is 320.02 subsection 4.
Thank you. Your bonding amount?
I would be requesting $2,000, Judge. There was a bench warrant in this case, and pursuant to the statute, we'd be requesting the $2,000.
Madam Public Defender?
Yes, Your Honor. We'd be asking, it's our position still that even under this statute, Your Honor has the discretion to issue a lower bond amount, given that this is just a traffic offense. We'd be asking for a reduced bond with pretrial services in the alternate.
And Judge, if I may, the statute says shall. I don't believe there would be much discretion in that case, and with that prior bench warrant, the state seems that the $2,000 would be fitting.
The original bench warrant amount was $1,000. I'll set the bond at $1,000, although I understand and concur with the interpretation of both my public defender and state's attorneys today. I think they're both probably correct. Shall means shall, and I do understand that. But under the nature, I'm supposed to look at certain factors, one of which is what is the charge? All right. Good luck to you, sir. I'm reducing it to 1,000, Madam Public Defender. And I want to thank my staff, the clerks, all of the fine people that represented both our state's attorney's office and our public defender's office did a fantastic job today. We're going to take a brief recess at this time, and then we'll start, I presume, Madam Clerk, with the felonies, yes? No, 130 juveniles. Last but not least, just for the record, we're going to
Your Honor, how long is the recess?
probably 15 minutes at the latest, if that's acceptable. Good for corrections?
Thank you.
Okay.
Yeah.
Thank you. May I return this to you, Mr. Lovelace or Mr. Rivas? I'll return that to you. You both did a fine job this morning. You, I presume, will not be with me in the afternoon. Right?
Will.
Oh, you both will?
Yeah.
Okay.
Lena, can you pick up the phone, please?
She said, please call upstairs.
That's actually.
They were just leaving. All right.
That's 20 pages for the video.
Okay, and I'm gonna, if it's, okay, we'll leave that just the way it is. We'll take a brief recess. Thank you. Say again, I apologize.
It's 54 defendants, 20 pages.
Okay, thank you. Thank you. And your name?
I'm Eric Bennett.
Eric, nice to meet you. All right, we'll take a brief recess. We'll be right back.
Not see. I think he's a video. This one, yeah, he just sets it for that.
Ready? Yeah. I also have a private attorney.
I have family in court.
Yes. Okay.
We're gonna have to go this way. Okay.
Why not?
It's hard to do this. Tomorrow.
Because you don't want to see. I don't.
6 pages of back. Oh, okay, so, yeah, it was 20, 35. Which is tough, but you know, I figured it's like stuff. And that's my mom, it's nothing. Cause I come out late, no, she a little more on Friday, and then
She wasn't here Friday.
Thursday, she was coming more on Thursday, and then she was like, I was with her son.
And she's not gonna be back Monday, supposedly.
What do you mean supposedly? She said she'd be back Monday, she said Thursday.
Did? Yeah.
I will live here on Thursday. But
Never mind. What did she do? Tuesday, she was discussing what mentioned.
no, yeah, Grace, she's just coming back.
Okay. And you got a little up to date. Forget.
I was here there. But I read one idea.
Did you ask about the A form?
Yeah. I think. So when we started with okay, for himself first, but then it's read article. Okay, more for a copy. But like, what we plan on doing a straight shot is page 11 part. But that's the Drew count from him all the way to the.
First, and then
I'll come back.
it's fun.
Yeah, it's not possible. Battery rates.
Yes, 35. 35. We're at 11.
Yeah, it lives in my back.
So you can true. Well,
I have no idea. I assume, Robert. I have no idea actually. I assume they do, but I assume that like, I assume that. Oh, really? Yeah. Look at him. Did you really grab your 50 word? Oh, no, that's right.
I will be done.
And there's also for Tom, right? Their flashes, they don't there.
No, because I start. No. This name looks familiar to me. Why does this name look familiar? Lawrence Keenan. Why do I feel as if I've seen him before? You know, I did dress up as Abraham Lincoln one time for a Halloween contest, right? Yeah. So, and I got second place. So a firefighter. Somebody dressed up as a firefighter, gave his actual firefighter out.
To be fair, firefighters don't.
Oh, 1,000 times more attractive. That was cheating. You're not even dressing in a costume. You're dressing in a uniform, an actual firefighter uniform. Because you're in school for it. That's not a costume. Where am I? Is my mask.
Down just in case, but I'm really confident.
My natural form out of the wild is the Adam Sandler, basketball shirts and superhero shirt.
So like on my days off, that's how I dress. Like I'm just in sweatpants and oversized t-shirts, and my mom goes, "Can you dress nice?" I'm like, "No." Summoning out of time.
My uncle, you haven't even packed a bag? Yeah, I'm like, what am I packing for?
Okay, so my
Oh,
mom.
we can have mine. So 3 basketball shorts, 3 t-shirts, underwear, socks.
No,
Oh, no.
Jared, my mom, that's I packed the day for it, and she packed like a month or 2 months. But I told my mom one day I just want to pay you to go out on vacation. Pack it. That one.
You telling me that we're going to go on a week-long trip to somewhere and then you're out of that?
No, I still do it there. The only thing I forgot while I was on vacation was the cables to project my connect my projector to my computer. I was a big one.
Mine's just so old that I'm just green.
$60 and when it came to the remote, the little stand.
Mine's just so old. The stand broke.
It's literally like this big. I have a lounge car bag, but
Mine's like that big, that big. The top is a touch screen so that you can actually control it like a mouse. You have your keyboards, you can make keyboards. But it's so old already that it's just like grimy. And the newer projectors have way better image quality.
I think I got that one last. I don't know if that comes from me.
It's silver things that have them.
Saturday on my computer. I'm charged since my annual. I also go shoot.
Oh, I have a sticky right there.
I have.
Yes.
I and then for me, she's like, "Can you put it for the 27th?" I was like, "No, I don't." I mean, and then she went for it to the 24th. No.
And Marlene was offering me that side. I told her, yeah, I told her I could understand if I didn't get it.
Yeah,
I'm not gonna be upset and green with that. But at the same time, I can just throw them up.
No, I mean, I see you just take it out.
Yeah, those are priors? Yeah, these are priors. Oh, fine. So who's on 35? What's the name of the hundred?
Last name Key. Not Clark, sorry, first name Key.
It's basically everything's in order, right?
Yeah, it's just two files. This one, except for this one is private attorney. I put it on top to see if corrections can get them first. If not, no biggie. But this is correct substance unless the private attorney. That's all I have. If there's anyone on the Zoom, you got the side, I don't know.
I don't care about having a calendar in my face anymore. It does nothing for me. Doesn't help me.
When I read it on the weekends, during the week, it's a little bit harder for the wizards. Well, actually, it's easier to knows like the bonds or whatever, so I don't need to tell it. But I'm always writing down whatever the judge says. And then I told them because then it gets much. But it's standard and written on the calendar, it's just me.
Yeah, because you guys have more than one juvenile. There's only one cricket.
Oh, are you trying for this morning?
Yeah, we have 2 direct files up here still.
No, yeah. You did one yesterday. I did the other test. Got it correct.
There's no other one? Another one?
No, I took it.
Okay, okay. I thought there was another one this side now.
So actually printed 2. Got rid of one of them because they updated it, and that's how you did yesterday. And then I took the other.
I thought there were 3 in total. No,
There was. I did it on. There's so much. And she heat too. But one thing not case.
You eat something. I'm trying to do the soft part.
Your card is the teacher. Play the South Park games. I just watch all of them. And then I sing. And then I do this one. I've watched South Park like 30, 40.
I have lost count. Like honestly, I wish certain episodes I could just watch over and over again. So those camera like that. You go on last body. You think I'm joking? What? Oh, that's the song.
Yeah. Number 24. Okay, all that.
We're on the 24 page.
Actually, yes, we can.
Blue, page 7, read name. Name blue. Banco. Banco. Banco.
Oh, we're supposed to find out when he has any great.
Why is it that maybe they call it up and trying to bond them out? Why is that?
Yeah, you- Yeah. You want to start?
I want to say by 3. I want to. But I don't know this piece. I've never worked. Never worked.
All rise.
You may be seated. Thank you. Again.
There was some item terms.
They're ready to be sworn in.
Yes. Good afternoon, everybody. All rise, raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? If so, say I do. Interpreter, have you been sworn in already? Yeah, I'm pretty sure that. So I put them first because I thought they had.
Start at 30. Oh, shoot.
Apologize, Your Honor.
Take your time.
This one.
Okay. And could I have our public defender's name for the record?
Andrew Black for the public defender. Good afternoon, Judge.
Good Welcome, everyone. Judge King here. If we're ready to proceed at this time, we're going to start calling the cases. We have about 52 cases on the calendar this afternoon. I have one counsel who's present. Yes?
Yes, good afternoon, Judge. Jara McLawrence. I'm here on behalf of Arthur Reed.
Very good. We're going to call that one right now.
Thank you.
Could we call Arthur Reed, please? And we have present his attorney.
Arthur Reed. Arthur Reed, come on. Yeah, they got a private attorney. Yeah. Arthur Reed.
Do you know what number Mr. Reed is?
Mr. Reed is on page 5.
Thank you. I'm gonna help you spin around, okay? Your attorney's on, okay? Your attorney's on. Your attorney's in the courtroom.
All right. We're here. Mr. Reed has been charged in this case. Mr. Reed, your attorney is present in the courtroom with me. And this is a felony in the second-degree battery aggravated with a deadly weapon in violation of Florida Statute 784.045, subparagraph 1, subparagraph A, subparagraph 2. I think your counsel wishes to address the court, and then we'll hear from the state's attorneys.
Thank you, Your Honor. Your Honor, Mr. Reed is a 75-year-old U.S. Army veteran. He's retired after 35 years of working as an electrician for FPL. He exists on a fixed income. He has resided in Miami Gardens for the last 50 years. He has a daughter here, and he also has a grandchild here. Your Honor, he has serious health issues, including he has a serious heart condition. He has serious psychosis issues. He has diabetes. He also uses an oxygen tank so that he can stay lucid most times. Judge, in this particular case here, I spoke with the detectives the law enforcement officers who handled this particular case. And we arranged for a date when I could bring Mr. Reed to the police department in Miami Gardens, which I did. We brought him to Miami Gardens. We sat down with the detectives. We spoke with the detectives about the matter. I think everyone involved here, including the detectives who spoke with the alleged victim in this case, are of the opinion or of the notion that there was no intent here. Intent is lacking here because of Mr. Reed's mental situation. I know this isn't the court to argue intent, and I know that's going to come up later, but it's also going to be a competency issue as well, Judge. Your Honor, I was asking for the court to provide Mr. Reed with a reduced bond for the purposes of allowing his family an opportunity to find placement for him. He was being seen and treated right here down the street here at the Veterans Administration, and they're trying to see if they can get him placed into their mental health crisis unit. So I was going to ask the court if the court could provide a reduced bond, maybe of $500, give them enough time to find placement for him. And then if they do find placement for him, then they'll bond him out. If they don't, then he will stay in custody until such time as they're able to find proper placement for him.
Thank you. Response, State.
Judge, well, understood that the allegations that are here in this case are, quite extreme. We would be asking for bond to be set at the amount of $5,000.
Reply if you wish, counsel.
No, Judge. Well, he's, like I mentioned to the court, he exists on a fixed income, Judge. So $5,000 bond to him would be tantamount to no bond.
Based on the representations of the state and the council in this case, I'm going to make the bond $2,000. I don't believe 500 would be adequate, but at the same time, I don't feel that under circumstances that he's at risk of flight or anything that would otherwise be of greater concern to the court. So at this time, $2,000 bond. And you would be not guilty in here? Oh, yeah. I'd like the 2,000. That's it. That's it. Last but not least, counsel, you can advise your client, but there's going to be a stay away order from one Mr. Wendell Brown. He may not at any time be within 500 feet of Wendell Brown, the victim's home, place of employment, or school at any of those times. Mr. Brown doesn't live with Mr.
No,
Reed.
Mr. Brown was his caretaker. So Mr. Brown was at Mr. Reed's home when this occurred.
So we're okay. Yes.
Stay away orders. The judge's right. SAO.
Thank you. Good. Good luck to you. Thank you for being here.
Thank you, Judge. Thank you, State.
Announcement for the interpreter for a second one.
Please.
Okay, Mr. Reed, we'll see you soon. Take care.
Good luck, Mr. Reed.
Hello, we've been trying to contact your office because we're in need of a Vietnamese interpreter and we cannot get in contact with anyone. Can you please see if we could get a Vietnamese interpreter?
Do that. I can call the language line. Just to confirm, this is Vietnamese, right?
Vietnamese, yes.
Okay, thank you. Sure.
That was it.
Say again?
This lovely set is piled.
And we have 2 files, yes?
And
Okay, no problem.
this one should be fast.
Thank you. Okay, the next case on the matter for this afternoon is Gerald Clark. King Jaja, Gerald.
Reset tomorrow, NBC, Judge.
Reset tomorrow. You are, sir?
I'm his father.
You're his father. Okay. It has to be reset for tomorrow. And so.
Huh?
Right here, just NBC.
Okay. I was trying to bond him out.
Reset and tomorrow's date.
It'll be reset, and tomorrow, the same time, around 12 noon, we'll be bringing him before the court. All right?
All right.
Thank you for being here and assisting us.
Okay.
Judge, for Mr. Clark, can you provisionally appoint the public defender?
Granted.
Accepts appointment. Thank you.
So I won't be able to bond him out today?
Not today, tomorrow. Maybe so, yes, tomorrow. Okay. These are what? These are the
No corrections asked for out of turn. Not be.
got it. Miguel Angel Gomez. Mr. Gomez is present. Mr. Gomez, you've been charged with 3 separate counts, actually 2, excuse me. A felony of 3rd degree grand theft of the 3rd degree in violation of Florida statute 812.014 sub 2 and organized fraud, $20,000 or less. Violation of Florida statute 7034, subparagraph 4, subparagraph A.
These are added charges.
Court finds probable cause. As
Judge, I have PC arguments.
you may, Mr. Black. Thank you.
So thank you, Judge. Also, Judge, could you just go ahead and make a blanket provisional appointment of the PD for all upcoming defendants?
Granted. Thank you.
Thank you, Judge. So on both of these cases, Judge, organized fraud organized scheme to defraud requires a systematic continuing course of conduct. What is contained in each of these A forms is simply allegations of grand theft. The officer saying that Mr. Gomez is currently facing trial for similar allegations does not make it a continuing systematic course of conduct. That scheme to defraud has to be alleged specifically in the arrest form. So all we have here is PC in each form, A form for 1 count of grand theft.
Judge, this is 1 case out of 11 open cases that the defendant has for the same charges. In the A form, the officer did list that this is not isolated way. This is just for this particular case, and additional cases will be forthcoming and have already been heard. There is an organized scheme here, and it's detailed here, of the fraudulent scheme of which this defendant is accused of. Therefore, the state would argue that there is probable cause for both charges.
I would just follow up by saying, Judge, that scheme, that MO, over the course of several cases, it has to be specifically alleged in the arrest affidavit. It has to be contained within the 4 corners of the A form.
I think it substantially complies. There we go. I'm going to go ahead and deny the request for a dismissal based on the arguments made by the public defender and or that there doesn't exist probable cause. I believe there does. There was a 3rd count. It says ZO, hold for magistrate, Florida statute 995-986. I'm not familiar with ZO.
That's not a count.
It's only 2 counts, Judge.
Let you know that he has a whole.
What's the bond amount as to count 1, please?
Judge, we'd be asking for $7,500, an elevated bond of $7,500 per count in this case, each with Nebia as well. And that's due to the 11 open cases for this scheme.
Granted, at this time, 7,500 count 1, 7,500 count 2.
And Judge, you could close with Nebia?
With Nebia.
Yes, 2 cases.
Thank
you. Yeah.
This is for 993, 7,500. There's another case that he should have.
It was on 9982, Judge.
I have 941. The numbers ending 941.
That is the police case number for court case number 9982.
I apologize, 9982, thank you. We had a second one, it was tucked in the back, Mr. Black, sorry for your inconvenience.
That's okay, Judge. I made PC arguments for both.
Then therefore my stand, if the allegation similarly situated, 7,500 for count one of this case number ending in 9982. Is that correct?
Yes, sir.
75.
You just did that case. It's 8-3. We on, right?
He wrote on 8-3 already. On 8-3, he put 7,500 each count.
And on 4-1, we're putting 7,500 each.
This number, not that number.
I keep looking at the wrong number. I apologize. They're right next to one another. Yes, 9982. Thank you. Good luck, sir. Thank you.
So, Judge, everything is 75 with Nebula on each case, all
Correct.
counts.
Thank you.
Yes.
Give you that back.
Your Honor,
Yes, sir.
Your Honor, I do have the Vietnamese interpreter on the line. I'm going to merge the call. It's actually through language line. Will you give me 1 minute, please?
Yes, please.
1 second, thank you.
All right.
Yeah. The defendant's name that's going to be called out of turn is Van Co Lu, L-U-U.
Can we pass until we finish Metro West, please, Judge?
He's currently being held at Metro West.
No,
No, he's present. Can we pass him until we finish these defendants who got to go back on the bus?
they want to do this file first.
Okay, the problem is the interpreter has the Vietnamese interpreter.
Okay, put him in. We can put him in, Judge.
I'm sorry. Okay, let's do it that way. We're gonna, is this,
Sorry,
What was the first name? Van Lou?
I don't know.
Who needed the interpreter? Who needed the interpreter, you know?
Your Honor, can you hear the Vietnamese interpreter?
yes, we do. And we're ready for, they're calling.
He's asking if we hear the video.
And what number is this defendant, corrections? Thank you.
Sir, stand, no.
Stand right here, okay? You look there, all right?
Your Honor, I have the interpreter on the line, but it's actually could be through on the phone, actually through either 786. Okay, that's it.
Thank you. Okay, let's hope everyone can hear us. Mr. Liu, you've been charged with a felony of the 3rd degree child abuse, no great bodily harm, violation Florida statute 82703.
Swear in.
Okay, and we're going to swear in our Vietnamese interpreter brief right before we get started here.
Hello, Mr. Interpreter. Do you swear that you will well and faithfully interpret from English to Vietnamese, Vietnamese to English, to the questions asked and the answers given to the best of your ability, and that you have that such ability? So say I do.
It's not for you. It's not for you.
I don't understand that.
We can't hear
English,
it.
okay?
No.
Okay.
Courtroom.
Okay, go ahead, Vietnamese interpreter.
Yes, I.
Okay, go ahead.
Good afternoon, Madam Interpreter. Hello.
Yes.
Hello, this is Judge King.
Hello, can you hear me?
I can hear you now. Yes, we'd like to swear you in very quickly. Our clerk's going to do that.
Please raise your right hand.
Yes.
You swear that you will well and faithfully interpret from English to Vietnamese, Vietnamese to English, questions asked and answers given to the best of your ability, and that you have such ability. So say I do.
Yes, I do. But I'm sorry, I have to say that the audio is like really bad.
Okay, we're doing this through cell phones and I'm not sure. Can you hear me or no?
I can for now, but like I'll try my best, okay? But I'm just trying to let you know that like the audio is like really bad.
The defendant, Van Lieu, is listening. Mr. Lieu, you've been charged with child abuse and third-degree felony. Madam Interpreter.
Dạ, anh Van Lieu, anh đã bị buộc tội là ngược đãi trẻ em ở tội trọng cấp độ 3.
The court finds probable cause for the arrest and the charge.
Thì tòa án đã có cái nguyên nhân để dẫn đến việc bắt giữ và buộc tội này.
Does the state have an offer?
Yes, Judge, it'd be standard bond in the amount of $2,500.
The bond would be $2,500 on this count.
Thì anh có cái tiền bảo lãnh đó sẽ là $2,500 cho cái tội danh này.
Also, there would be a stay away order issued.
Đồng thời, anh sẽ có cái lệnh tránh xa cái người đó ra.
In this case, anything from the public defender, Mr. Black?
Your Honor, I would only ask if the Vietnamese interpreter can tell Mr. Lieu that within the next day or two, an attorney will be reaching out with a Vietnamese interpreter.
Dạ thì trong một hoặc là 2 ngày tới đó sẽ có một luật sư liên hệ với anh cùng với lại một thông dịch viên tiếng Việt.
In the release pretrial conditions counsel, Mr. Rivas, it indicates that it's checked off that the defendant is allowed to have contact with the victim but prohibited from being physically threatening. Is that correct?
Yes, Judge.
Thank you. So he's able to return back to the residence?
He is.
So Judge, to clarify, it's a no harmful contact order?
Okay. Very good. Mr. Lieu, one last admonishment by the court. You must at no time harm GR, the minor in this case, at any time. Do we understand? Physically harm.
Dạ rồi. Anh Lưu, thì cái lời cảnh cáo cuối cùng của tòa án là anh không được phép gây hại tới GR, là không có được tác động vật lý đến cái người bị hại nữa.
Does he understand?
He understands.
Thì anh có hiểu không ạ?
Thank you. Good luck. Thank you, Madam Interpreter. We really appreciate you helping us today.
Just initials in the first page, and then here they write the full name.
Thank you for using our services.
You're welcome. Ariel Suarez. Mr. Suarez, you've been charged with grand theft in the third degree felony, violation of Florida statute 812.014, and a second.
I'm so sorry to interrupt, Judge. We're going to need an interpreter.
Got an interpreter present.
Okay.
So, if you would be so kind, he's been charged with a third degree felony, grand theft of the third degree.
El señor está enfrenta a un cargo de hurto en mayor cuantía. Es un delito grave en tercer grado.
In this case, that is violation of chapter 182.014, subparagraph 2.
Enquebrantamiento del Estatuto de la Florida 18014, subparágrafo 2.
Second count is felony in the third degree, petty theft. And it says two convictions.
El segundo cargo es hurto menor, es un delito menor en tercer grado. Ya había tenido dos fallos condenatorios del pasado.
Similar violation, but in this case, it's 014 subparagraph 3.
Y en este caso es un quebrantamiento del mismo estatuto, pero párrafo 3.
And Judge, I have a PC argument respecting count 2.
All right.
La defensa va a presentar un argumento en lo que tiene que ver con el segundo cargo.
We'll hear that at this time, Mr. Black.
So Judge, the A form only contains the allegations of the grand theft. I think the officer saw that he has 2 past petty theft convictions, and so they tacked on the petty theft with 2 or more convictions. That statute is meant to criminalize petty theft when the individual has 2 or more prior convictions. He's not accused of petty theft here. He's accused of 1 instance of grand theft. So that second count is not appropriate.
El abogado defensor dice que el segundo cargo no es apropiado a la luz de la manera como el oficial ha imputado los cargos.
Response.
Yes, Judge, 1 moment. Yes, Judge, I'm seeing here that according to the statute, when I'm looking at 812.014, it states specifically if the offender commits any grand thefts, that would fall under, because it is noted that there are 2 grand theft convictions that are stated on that A form, that there would be PC for the petty theft of 2 or more convictions.
El fiscal está diciendo que como ha habido ya fallos inculpatorios del pasado por delitos graves, sí debe haber motivo fundado para este cargo.
Mr. Black, what they're arguing is they're linked. Once there's the grand theft, then the 2 petty theft convictions can be considered by the court.
No, Judge, in order for a person to be guilty of petty theft, 2 or more convictions, there has to be an allegation of petty theft. So the section says theft of any property not specified in this subsection is petty theft of the second degree, et cetera, and then the enhancement is a felony in the third degree if they have 2 or more convictions. There's no allegation of a petty theft here. There's only allegation of the 1 grand theft, $19,225.
All right.
El defensor acaba de presentar también su argumento para decir que no hay motivo fundado para el cargo de delito menor.
So I'll just read right from the section, Judge. Subsection C, a person who commits a petty theft and who has previously been convicted of 2 or more times of any thefts commits a felony in the third degree. There's no petty theft alleged here, only a grand theft. So it's double jeopardy to charge him twice in this case.
Under the circumstances, I find probable cause for count 1. As for count 2, I concur with the public defender in this case. However,
dice el juez, yo que hay motivo fundado para el cargo número 1, sin embargo, para el cargo número 2 estoy de acuerdo con la defensa.
In the case that probable cause does not lie, and I find as such, the case would otherwise be set for division, judge, for dismissal, or do I do it right here?
No, Judge, if there's no PC on that count, you simply release him outright on that individual count.
Yes.
So there's no bond, there's no ROR, it's just release outright.
Entonces, si no hay motivo fundado ni hay fianza para el segundo cargo, simplemente es una excarcelación directa, ni siquiera libertad bajo palabra, sino simplemente una excarcelación directa.
Thank you. The bond on count one.
We'd be asking $5,000, Judge. Additionally, there is a felony hold, and it's elevated due to the felony hold is the exact same charges here.
Entonces, la fiscalía está pidiendo una fianza de $5,000 para el primer cargo y más encima, recuerde su señoría que hay una orden de retención del delito grave.
These
Bond
are
is
added charges.
dollars as to count one with the felony.
I didn't hit a bond for count one, Judge.
$5,000.
Es $5,000 para el primer cargo.
Also, Mr. Suarez, at no time upon your release, may you return to 350 San Lorenzo Avenue, Coral Gables, Florida, 33146, the location where the alleged theft occurred.
Señor, usted tampoco deberá, bajo ninguna circunstancia, regresar al 350 de San Lorenzo Avenue en Coral Gables, 33146, el lugar donde presuntamente ocurrió este hurto.
Good luck to you, sir.
What was
Buenas
count
suerte,
two,
señor.
Judge?
Say again?
What was count two?
Yes, second.
5,000.
No, release.
5,000 each?
Oh, I'm
Yes.
sorry. I'm sorry.
I found no probable cause on count two, release outright.
Thank you.
Thank you. Alexander Urquidi, Urquidi.
Motion for thought, is that true?
Mr. Urquidi, you've been charged with felony in the second degree, unlawful sexual activity with a specified minor in violation of 794.05 Florida statute. Felony in the second degree, count two, computer service travel meeting minor without, in out state child, in the state or out of the state by a child. That's a violation of Florida statute 847.0354. And there's a ZO hold for magistrate 995986. I did have a chance to review the affidavit of arrest, and under the circumstances, I find probable cause for count one and two.
Judge, I have PC argument as to count two.
Which is?
So, Your Honor, that statute requires a defendant to travel to a location in order to engage in sexual conduct after using a computer device or an internet device in order to solicit that victim. So that's not what's alleged here at all. That's not what's alleged in the A form.
Response, state.
One moment, Judge, if I may. Judge, the state would argue that there is probable cause for charge one and would defer to your judgment for count two.
I do not embrace the argument by the public defender in this regard, so I'm going to find probable cause as to both. There's an allegation that he was involved with this individual for 4.5 months, and specifically, I find that those arguably could have been at her location, not just his. So under the circumstances, for now, the court finds probable. Now, there is a request by the state's attorney that being charged with a felony of the first degree, these are felonies of the second degree, or a capital felony or a life felony, and therefore they're seeking to have him detained under this statute, which is 907.0415A, dangerous crime and offense, child abuse, aggravated child abuse. So is that correct from the state's perspective?
Yes, sure. According to the motion, these are charges that could be punishable by life, and according to the subsection, includes sexual activity from a minor, someone who's under 18 but above the age of 12, and therefore that's the grounds for that motion that we move for a hearing.
He's seeking a granting of a pretrial detention pursuant to 907.041. Response, Mr. Black?
So, Your Honor, if they've filed the motion, then they have 5 days to argue it in front of whoever the trial court will be. And so if they file the motion, then that's where we are here.
As the bond duty judge, under these circumstances, I presume that I must sign this order. And then 5 days from now or earlier, there will be a hearing.
So, Judge, what I would only ask is that the case be reset to Monday for this PTD motion to be heard before the trial court. That's typical practice.
It will, Your Honor, Monday, 9 a.m. with Division 13.
It will be Monday at 9 a.m. before Judge Hirsch.
What is the bond? No bond?
I was gonna say, you're gonna apply the no bond to the charges that are associated with that.
Thank you. No bond as to count 1, no bond as to count 2.
There's 6 counts here.
3, 4, 5, 6.
Oh, boy. Wait a second. Oh, yes. I apologize. So 5 counts as to count 1. That would be 1 through 5, I presume. Yes?
Yes, Judge.
And
so, Your Honor, I'm sorry to hold us up here. The PTD section of this statute, it specifies sexual activity with a child who is 12 years of age or older but less than 18. But then the relevant part is by or at solicitation of person in familial or custodial authority. These are not F1 charges, and what he's alleged to have done is not captured under that definition under subsection 5 of 907.014. So I don't think there's any authority to hold him no bond pending a PTD hearing.
respond.
1 moment, Your Honor.
Judge, yes, seeing that, we would be revoking that motion, and we'll be requesting in substitution a bond in the amount of $2,500 per count.
$25,000.
$25,000 per count.
I stand corrected, and I think, I don't know if you heard that, Mr. Black. They're withdrawing their motion for pretrial detention. They're seeking a bond of $25,000 per count.
So, Judge, what is the basis to request an elevated bond? He can't afford $25,000 bond per count. It's tantamount to no bond, which is exactly what they're trying to achieve with the PDD. So it's trying to hit the same goal, but they're not able to do the PTD, so they're asking for an elevated bond. What is the justification? What is the basis?
Sexual activities with a minor over the course of 4 months.
Judge, there's standard bond for that. There's a standard bond set for that. He can't afford it. He's not going to be able to bond out. He's entitled to a reasonable bond. If it's not punishable by life felony, or if it's not something included under the PTD statute, it's unconstitutional.
It's a $5,000 bond under the recommended administration order by the chief judge. I've got the brand new 2025 weekend bond duty training manual right here. So, and I did read it. I'm going to correct all of these where I had issued for Mr. Black's edification. No bond will be $5,000 per count of the 6 counts as otherwise mandated for. I got it correct. Right, 3rd-degree felonies. Okay. Second degree, excuse me. Thank you for the correction. It stands at $5,000. Yes, so that doesn't get issued. I'm so sorry, I was reading. Oh, by the way, it's actually refreshing to put the judge's name immediately above. the name. And I stand corrected, and my apologies to Judge Michelle Delancey. I stand corrected. No, this would
We're on
be
Mr. Garcia now?
you.
Manuel Garcia.
I don't think this is you?
Yeah.
Oh, okay, you look good.
Mr. Garcia refused court, reset tomorrow.
Thank you. Is that all we need to do? And right here, Matt?
Yeah.
Just right there.
On the back. On the back of the.
Also on the back.
Use, reset, and we'll probably date.
Tomorrow, I guess.
Yep. 5/18.
How about Travis Williams?
What is it? No, that's a refusal, Judge. What number is he?
Reset tomorrow, refuse court.
All right.
National section.
So now we have 45.
Yeah. And after that, the rest of them should be already.
Rivera. Christina Rivera. Now I'm doing it again. David Garcia Portmane. Thank you. In this case, sir, you've been charged with a felony of the 3rd degree battery by a detainee or other visitor.
I'm sorry, Judge, I'll need the assistance of the interpreter.
Got it. Thank you, Counsel.
In this case, he's been charged with a felony of the 3rd degree battery by a detainee on a visitor or other detainee.
Señor, frente al cargo que es un delito grave en 3er grado, es agresión física de un recluso a otro.
Violation of Florida Statute 7.82.
Judge, I do have a PC argument here.
El juez, perdón, el abogado defensor tiene un argumento.
We'll hear from the public defender.
So, Your Honor, I've read the A form. I see an allegation that Mr. Garcia was slapped. I don't see an allegation that he ever returned the favor or touched anybody. I don't see that in the 4 corners of the A form.
El defensor dice, señorillo, aquí no veo yo veo que le dieron una galleta cachetada, pero no veo que él haya regresado ese, o que se haya involucrado en eso de alguna manera.
Nunca. Yo nunca le pegué nada, él me pegó a mí.
I never hit anyone, he hit me.
State.
Mire mi cara.
We can mute it.
We'd stipulate, Judge.
Say again?
We would stipulate that there's no PC in this case.
No probable cause.
Dice el fiscal, no hay motivo fundado.
That is released.
Back to custody on what was previously holding him.
Entonces le ponen en libertad otra vez al lugar donde lo tenían recluso antes.
Release outright, Judge?
Yeah, but he's still standing.
Yeah. Yes.
Okay.
He will go back to custody on the other.
He's going to be released outright on this charge. Thank you. Thank you, State. Next case. A case of Mark Anthony Colon.
I don't think we have Mr.
No, they don't say refuse.
Oh.
Refuse court, reset tomorrow.
Thank you. Next case will be the case of Carlos Lopez. I said that wrong. Alton Antoine Bird. I'm going to bring these over closer so I see them.
Refuse court, reset tomorrow.
Thank you. Next case, Jerry Alfred.
Refuse court, reset tomorrow.
All right, give me 1 second. I'm writing all this in here so that we get it down. Javon Washington.
Refuse court, reset tomorrow.
Next case, Isaac Lumpkin.
Refuse court, reset tomorrow.
Craig Mack.
Refuse court, reset tomorrow.
Next case is Arcida McLeod.
Refuse court, reset tomorrow.
Next case, Adam Gonzalez. Adam Gonzalez.
Refuse court, Judge.
Thank you. How about Gianni D'Angelo McIntosh Jones?
Refuse court, reset tomorrow.
Thank you. Next case, Donita Thurman. Good afternoon, ma'am. You've been charged with felony in the first degree cocaine delivery within 1,000 feet of a church convenience store in violation of Florida Statute 893.13, subparagraph 1. Court finds probable cause, standard bond state.
No, Your Honor. No, Judge. This is a punishable by life offense, and thus we are filing a motion for pretrial.
Motion for pretrial detention is being filed in this case, Mr. Black.
Judge, a motion for pretrial detention is only appropriate in drug cases when it is trafficking in any controlled substance described in 893.1351C4. Those substances are altentifil, carfentanil, fentanyl, and a number of other substances that are not cocaine. This is not a punishable by life first degree felony. It is not an offense that is captured under the pretrial detention statute. So standard bond would at most be appropriate.
One moment, Your Honor.
Thank you.
This is not in that statute. Yeah. All right. Go to the back.
Then we'd be asking for standard bond in this case, Judge, in the amount of $7,500.
$7,500 standard bond. They're withdrawing the motion for pretrial detention.
Yes, Your Honor.
Thank you. Next case.
I'm sorry, Judge, that was a 7,500?
We dismiss this defendant. We are issuing stay away order.
Thank you, Mr. Black. They would like me to sign a stay away order from the location where the defendant was allegedly arrested. That would be 2050 Northwest 54th Street, Miami, Florida. That he shall not return at any time to that location until further order of this court.
Thank you, Judge. And I'm sorry, that bond amount was 7,500?
7,500.
Thank you.
All right, come on.
The next one is Tanika Tori. Ms. Tori, you've been charged with a felony of the 3rd degree, count 1, by sudden snatching, robbery by sudden snatching, 812.131 sub 2, and felony of the 3rd degree, grand theft in the 3rd degree, Florida statute 812.014 subsection 2. Give me a moment to read the arrest form. Court finds probable cause for the charges in this case. Is there a bond from the state perspective?
Yes, Judge, we'd be asking for an elevated bond as to the sudden snatching charge of $5,000 and standard bond for the grand theft charge in the amount of $2,500.
Your Honor, may I be heard?
Count 225. Yes, sir.
So, Your Honor, I would ask for an alternative to monetary bond. She's not going to be able to afford it. She has 3 kids at home. There's nobody else that can take care of them. Their grandmother is watching them now, but she's not in a state to take care of them longer term. She's not going to be able to bond out. Defendants are entitled to non-monetary bond. There are alternatives. We can send her through the TPS, the pretrial services program, which requires her to check in. It requires she have a stable address. She does. If Your Honor's not comfortable with that, there's always the option of putting a GPS monitor on her. But there are options to address the concerns of the bail statute, which are unreasonable risks to the community and appearing for court. Based on those concerns of the bail statute, I even think that ROR would be appropriate. But if Your Honor is not comfortable with that, there are non-monetary options for Ms. Tori.
Dave?
Judge, Ms. Tori is a clear danger to the community. There are multiple battery charges that have been filed against her. There have been one withhold on a misdemeanor battery, as well as a felony misdemeanor as to an aggravated battery with a deadly weapon. We stand on our request for the bond amount of $5,000 for the sudden snatching, as well as grand theft. Additionally, the circumstances of this case, there was violence in this case as well.
Count 1, you're seeking what type of bond?
Elevated bond of $5,000 to the robbery by sudden snatching, and then as the grand theft charge, $2,500.
So, Your Honor, I would just respond. She has not been arrested in Miami-Dade County in over 10 years. And so she is not an unreasonable risk to the community. Even if she did get into a domestic dispute in public, that does not make her an unreasonable risk to the community. Unreasonable risk to the community, you can find it under subsection 5 of the bail statute. It's things like kidnapping. It's things like murder, arson, terrorism. It's not this kind of charge. And whatever the case, Judge, she has 3 kids at home that need her. She's not a risk to the community. She'll show up to court. A non-monetary option is appropriate.
In this case, I'll give following an alternate bond pretrial services, count 1, $2,500, count 2, $500. Yes. And Ms. Torrey, you may not at any time be within 500 feet of Mr. Marshall, who was involved in this incident, nor directly or indirectly contact him in writing by telephone, pager, fax, or other through third parties. Do you understand? Ma'am?
You said yes, Judge.
You understand you may not go to his place of employment as well.
You understand?
Yeah, I understand.
Good, thank you. Good luck to you, ma'am. Next case, Juancetta Sabrina Green.
Come on, Miss Pink. I'm sorry, Mom. Go ahead. Miss Green, stay right here.
In this case, Ms. Green, you've been charged with felony of the first degree manslaughter and aggravated elderly disabled adult in violation of 782.07 subsection 2.
Yeah, you're gonna have to catch it.
I'm reading the arrest form affidavit. Court finds probable cause in this case. Mr. Rivas,
The state's filing a motion for pretrial detention in this case.
they filed a motion for pretrial detention. They're seeking no bond. I believe they qualify on this fact pattern. No bond. And the court is granting the request to have this matter heard before the division judge on within 5 days of the which will be Monday. Thank you. Good luck to you, ma'am. In this case, we need to put PC or just no bond? Yeah, thank you. Next case. Naisha Alston. Miss Alston, is that you?
Yes, sir. This is her.
You charged with a felony of the second degree, battery, aggravated with a deadly weapon, violation of 784.045, subsection 1A. Reading the A form. In this case, the court finds probable cause.
Judge, I have PC argument.
Sure.
So, Your Honor, she's charged with an F2 battery, aggravated battery with a deadly weapon. A deadly weapon is defined as any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design. An object not designed to inflict bodily harm, like a dart, for example, may be a deadly weapon if used or threatened to be used in a manner likely to cause death or great bodily harm. I don't think that's what the A form alleges. The victim reports a sharp pinch in his lower stomach area. I don't think it rises to the level of assault or rather battery with a deadly weapon. based on the definition within the jury instructions.
Thank you. Response, State.
Judge, according to the A form, if we turn to fourth paragraph on the second page, it is an unknown sharp object in her hand as she was charging the victim here, and that the defendant did have that unknown sharp object. While yes, there was a small black dart tip, we conclude that one, any sharp object could cause harm. It could be considered a deadly weapon. There are cases where a shoe heel has been considered a deadly weapon, and here, as this was being used, it is alleged within the four corners there is probable cause.
I would just respond, Judge, by saying that an object that's not designed to inflict, not designed to be a deadly weapon, in order for it to be counted as a deadly weapon, has to be used in a manner likely to cause death or great bodily harm. So if she had gone for his eyes, if she'd gone for his jugular, that I think that would rise to the level of an F2. I think the fact that he was touched with it in the abdomen area and it's a small black dart, I don't think it rises to the level of an F2 in this case.
Thank you. Well argued by both sides. Probable cause found in this case. What is the bond?
The bond would be $5,000, Judge.
$5,000.
May I be heard on the bond, Judge?
You may.
So, Your Honor, I don't see any, so I see one null pros case from 2021. I don't see an extensive history of arrest, no convictions. She's not a risk of danger to the community. If the allegations are true, there was intoxication involved. And if the allegations are true, what the allegations are is that she was beat up by two guys. The allegations is that she spit on somebody and that a man responded to her spitting by shoving her to the ground. She was subsequently struck. She was subsequently kicked. So, Your Honor, in this case, I think it's appropriate to allow Ms. Alston to go home. I think PTS is more than appropriate. It allows the court to keep tabs on her. I don't see a justification for a non-monetary bond.
Got it. Any objection to an alternate bond, PTS?
Yes, Judge. While there are no priors from Florida in New York, there is a felony conviction of assault in the third degree. There's additionally other charges as assault in the second degree. There is a aggravated battery. There are multiple different New York charges that the defendant has in this case, so we will be standing on our $5,000 bond.
Thank you. $5,000 bond stands. At this time, good luck to you, ma'am. Lastly, if you're able to make bond, you may not at any time have any contact with Hector Faez, F-A-E-Z, going to him directly, indirectly, writing. Do I have the right person? There are. Somebody did too. Defendant must stay at least 500 feet away from the victim's home, place of employment, and school at all times. May contact at no time the victim in this case as alleged. Thank you. Yes, thank you. Next case, Nicole Montano.
It's a bond out.
Thank you. Next case, Maria Fortunato. Ms. Fortunato, can you hear me, ma'am?
Yes, Judge.
You've been charged with a felony of the third degree child abuse, no great bodily harm, count one, and there's two counts of that under Florida statute 827.03 sub 2, and a misdemeanor, the first degree battery, violation of Florida statute 784.03. Court finds probable cause for counts of child abuse, no great bodily harm, and probable cause for the misdemeanor one battery. In this case, state.
Sorry, Judge, do you know why there are 2 counts of the child abuse?
Let's ask. It looks like to me, and I'm just reading from this. It does appear that maybe that might be a typographical error. It looks like it's one striking of the child alleged.
Yes, Judge, I believe it's most likely an error. Well, it most likely should be 1 count of.
1 count, and I'm going to initial that and change it to 1 if that's acceptable to the state. Or does the state have to do that?
I believe the state has to do that.
But we can enter, I guess, no PC for count 2.
Yes, Your Honor.
Well, if you all realize it was 2 in the first box and 1 in the second. So there in essence are 3 counts currently, unless you withdraw one of the 2.
So
felony with 3rd-degree child abuse.
Your Honor, I think what the state is asking for here is we'll be asking for a $2,500 bond on 1 count of child abuse. We will ROR on the second, and then be asking for a $2,500 on the battery.
No, Judge, that's not correct. When there's no allegation for that second child abuse count, there's no PC for it, which means she's released outright, not ROR.
You're correct, counsel. My apologies.
Okay, thank you.
2,500, count 1, release outright. Count 2. And the bond for count 3, so to speak, count 3, that would be the misdemeanor 1st-degree battery.
We'll be asking for $1,000, Judge.
1,000, did you say?
1,000.
Granted.
Okay, so I'm sorry, that was total 3,500?
Yes.
Okay.
All right. And in this case, if you're able to make bond, ma'am, you must at no time have any contact directly with Dayton Padron. Now, this, I understand, seems to be her son.
Your Honor, I put the name there. If you look down, the note that I made was for her to not harm the child. There's no offensive contact later.
No harmful contact order, okay?
If you are able to make bail and bond and bound out of jail, you're not engaged in any criminal activity, not to use or possess any illegal drugs, not possess, purchase, or carry a firearm, gun, weapon, ammunition. You must immediately surrender any firearms and ammunition and conceal these weapons. Take them to the nearest police department and obtain a receipt for tendering of those weapons. In this case, you are allowed to have contact with the victim, but it is prohibited from being physically threatening or violent towards the victim in any manner. Do you understand?
Yes.
Good luck to you, ma'am. Next case.
Jenkins.
Ronald Jenkins.
Jenkins. Ronald Jenkins.
He's in a wheelchair, Judge, so it may take a second.
Thank you. The what? I believe that's because that would have prohibited any contact at all. We'll have him put it back in, and I'll initial it.
We can make another one.
Just raise your name.
Yeah, just right. I got it.
I will not, because it makes it in those copies, right? Thank you. Good afternoon. Mr. Jenkins, you've been charged with a felony of the second degree, tampering with a witness who is a victim of a third degree felony, in this case assault. It's a violation alleged of chapter 914.22 subsection 2. In this case, the court finds probable cause for the charges. What is the standard bond?
Your Honor, the standard bond in third degree felony would typically be $2,500, but they would be asking for an elevated here of $25,000.
And tell me why.
The defendant was convicted. The defendant has a large criminal history. The defendant in 1997 was convicted of attempted second degree murder, and in the past has been convicted of possession of a firearm by a felon. In the last 5 years, the defendant was a convicted felon on possession of cocaine with intent to distribute, and eventually served. It was convicted, put on probation, violated probation, and entered a suspended entry sentence. Beyond that, the accusations and circumstances of this case are in fact correct. Here, as the A form notes, the victim in this case is involved as the victim of a case involving the defendant's son. The defendant then went and threatened the victim. So what we have here is an attempted murder conviction, threatening to kill a young woman who was already a victim of crime. And thus we're asking for $25,000.
25?
25.
$25,000 is request.
Your Honor, may I be heard?
Yes.
So, Your Honor, he can't afford that, which means that it's tantamount to no bond, which is unconstitutional unless it's a first degree felony, punishable by life, or it's one of the several offenses listed under the PTD statute, which it's not. And so, unfortunately, acknowledging the history, acknowledging the allegations, it's just not constitutional to give him a $25,000 bond.
Reply if you wish.
One moment, Your Honor. Your Honor, if we are discussing release, the problem here is the victim lives right next door. As noted.
So he's informing me, Judge, he does not live next door. But again, that is not a justification for an elevated bond when it's tantamount to no bond.
The problem, what we are facing is putting a convicted attempted murderer with serious priors, very serious priors, a convicted felon in the last 5 years, back on the streets, who threatened to kill a victim. That's what we're looking at here. And I'm not real sure that it's to the interest of protecting the community to not issue a lower bond.
I concur with the state, $25,000 bond. In this case, if you're able to make bond, Mr. Jenkins,
Yes, sir. Yeah.
I'll stay at all times. No,
25,000, I think.
at all 500 feet from the alleged victim in this case, Danita Grays. You must be at least 500 feet away from her home, place of employment, or school. You shall not contact her by email, texting, Facebook messages, or any other means. Do you understand, sir? I'm sorry, we can't hear him. We're saying
I don't want him to hear him.
we still can't hear.
Nothing.
I don't live in that area anymore, Your Honor. I moved from that area and I do not cause no problem. That's my past history. I know I have a history, but
So it was 25,000.
I don't do such thing like that to threaten nobody's life, Your Honor.
I wouldn't say anything else. Okay.
Thank you, sir. Good luck.
Yes.
At this time, next case, Jose Raul.
Hey, man, I told you. No, don't do that. Sit on down. I told you this is what we're doing. We don't need
I
no
gotta
problem.
come up with $2,500.
Yeah, that's your bumper. Whatever. I ain't gonna come up with no $2,500.
Stay where we were.
In this case, you've been charged, sir, with a felony of the second degree robbery, strong arm robbery, in violation of Florida Statute 812.13 subsection 2. I find probable cause. What is the bond?
State would be asking for a $10,000 bond here, Your Honor. We heard from the victim earlier this morning in the associated misdemeanor case that this defendant has threatened her a number of times, that this defendant has pulled a firearm on her a number of times. And so we're asking for a $10,000 bond.
$10,000 bond granted. Mr. San Martin, if you're able to obtain release, you're prohibited from having any contact with Catherine Sanchez. You must stay at least 500 feet away from the victim's home, the place of employment or school. And you shall not contact her in any way, email, text, Facebook, or other messages. Do you understand?
Yes, Your Honor.
Thank you. Good luck. Anthony Andrade.
Refuse court, reset tomorrow.
Thank you. Next case, Pedro Gonzalez. Mr. Gonzalez, you've been charged with burglary, with assault or battery with prejudice, with felony, and misdemeanor tampering with the victim's information, and misdemeanor conspiracy. The first count's pursuant to chapter 810.02, and the second count is 914.22. Court finds probable cause. Bond, please. Yes.
Pretrial detention.
Mr. Black, they're seeking a pretrial detention.
You're right. I heard you, Judge. Sorry.
Court finds probable cause, no bond, pretrial detention granted.
That's on each count.
So it would only be to count one.
Let's ask the state.
Yes, Judge, it would be applied to just count one, the burglary charge for the tampering charges. $1,500 charge.
$1,500 for count two. And I'm granting the request for now for pretrial detention hearing, which will occur on Monday, Madam Clerk?
Yes.
Thank you. Next case would be the case of Wilson Gerardo Ventura Varela.
Come on, sir. Ventura, Wilson Ventura, come on, sir.
Judge, she's out on probation, F-22-19396.
Thank you.
Good afternoon. Do you need an interpreter?
No, sir.
In this case, he's been charged with a felony of burglary of an occupied dwelling with a mask. And he was at the time alleged to be armed. Count 2, felony of the second degree, firearm, weapon, ammunition, possession in the hands of a convicted felon in violation of Florida Statute 790.23.
Yeah. And Judge, we will be filing a motion for pretrial detention as count 1.
Court finds probable cause.
Judge, can I be heard on PC?
You may.
So, Your Honor, a burglary of an occupied conveyance is normally a second degree felony. When you add the mask, it enhances it to a first degree felony punishable by as many as 30 years state prison. It is not a punishable by life felony.
Response.
And also, sorry, Judge, just one more thing. Under the PTD statute, which allows pretrial detention motions in cases that are not punishable by life, it has to specifically allege the offense. It specifically alleges burglary of a dwelling, and it excludes, or rather does not include, burglary of a conveyance. So this is actually just an F1 of PTD must be denied.
So the mask makes it 100.
They're reviewing it momentarily.
Thank you, Judge.
Yes, Judge, and we're reviewing it for offenses that are either charged with as a capital felony, a life felony, or a felony of first degree. I believe the state is allowed to file this motion for pretrial detention, and thus we do request that hearing.
Judge, that's not accurate. Subsection 5, 907.014 lists the offenses that are not PBL offenses for which pretrial detention is possible. Burglary of a dwelling is on that list. Burglary of a conveyance is not.
Is he correct, gentlemen?
It's forward. I'm checking now. Apologies, Your Honor.
Thank you.
Judge, while they're looking at that, I also have PC argument as to count 2. If you're ready. Okay.
I'm all ears, but they need to listen too.
Fair enough. Fair enough, Judge. Sorry about that.
Judge, we would be withdrawing our motion for trial detention, and we'd be asking for an elevated bond of $10,000 per count.
Probable cause argument. I've read the arrest form, please, Mr. Black.
As to count 2, the felon in possession statute, in order to criminalize carrying of a weapon, under that statute, that weapon has to be concealed. It has to be, excuse me. I'm sorry, Judge. That's not the argument I wanted to make. For this case, there's no allegation within the 4 corners of the A form that he's a convicted felon There's an allegation that he did state prison, but he could have been sent to state prison with a withhold of adjudication. We do have an attached priors sheet, Judge, but in this case, it's not alleged within the four corners of the A form, so there's no probable cause for this count within the four corners of the A form.
Judge, when I'm looking at the A form within four corners, if we're looking towards the last full paragraph on page 2, it states that an FCIC, NCIC criminal history check revealed the defendant was currently on state inmate release status regarding an original offense of aggravated battery with a deadly weapon. That is a felony. They are an in-state inmate. We'll be arguing that that would be enough to establish probable cause that he is a felon in possession of a firearm, and it's clear that he was in possession of that firearm.
So, Judge, it could have been a withhold, which means that he would have not been violating the statute.
Probable cause found in favor of the state. Well argued, Mr. Black, by
Thank you, Judge.
Your client. As to count 1, probable cause, yes. Probable cause also as to count 2. The bond is sought 10,000. Did you say count 1?
10,000 per count, Judge.
Per count, 10,000 as to both counts.
Are you placing a hold?
Also going to be stay away order from the victim in question, Mr. Peralta. You may not be within 500 feet of the victim at any time, may not contact the victim at any time. Do you understand?
Do you understand?
Are you placing a hold, Judge?
Good luck to you. No, because they withdrew their motion for pretrial.
No, Your Honor.
Oh,
He's out on probation.
he's out on probation. Yes. In this case, he'll have to do that. I apologize. That's okay, go ahead. And so, yes, thank you. Hold for division hearing. Thank you. Our next case is Roberto Jaime de la Vega. Mr.
Need the services of an interpreter, Judge.
Mr. De La Vega, you've been charged with a first-degree felony, trafficking in prescription drugs.
Señor, usted enfrenta un cargo que es un delito grave en primer grado que tiene que ver con traficar con drogas prescritas. Your Honor, for the interpreter, you said that's a first-degree felony, correct, Judge?
I did.
Thank you. Just confirming. Thank you, Your Honor.
It's a Florida statute 499.005.
Es en quebrantamiento del Estatuto de la Florida 499.005.
Also, he's been charged with count 2, a second-degree felony, removing dispensing labels from prescription drugs in violation of Florida statute 499.0051, subsection 13.
Y el segundo cargo que enfrenta es por quitarle la etiqueta a frascos o recipientes que contenían drogas prescritas en quebrantamiento del Estatuto de la Florida 499.0051, sección 13.
Got a count 3, That would be a third-degree felony, being in possession of cannabis more than 20 grams, suspected marijuana.
Y el cargo número 3, que tiene que ver con tenencia de cannabis, posiblemente marihuana.
After he gave permission alleged to search the vehicle, the suspect contraband was found. I find probable cause for the arrest.
Después de que el acusado autorizó a que el policía requisara su auto, se encontró el contrabando y se halla motivo fundado para el arresto.
Thank you.
Judge, may I make PC arguments? Don't say it. I'm sorry, Judge, may I make PC arguments?
Yes, sir.
As to count one, Judge, I don't see any allegation that he's trafficking. Trafficking is a very specific thing. The officer noted that he had five phones without knowing what's happening on those phones, without seeing transactions, without any allegations of transactions. It's just not enough. And so what we have here is possession under 893.136A. It's a third-degree felony, Judge. There's no allegation of trafficking.
El abogado defensor acaba de presentarle un argumento a su señoría diciéndole que el hecho de que se encontraron 5 teléfonos no implica que necesariamente había una transacción. El abogado dice que simplemente hay motivo fundado para la tenencia de esta sustancia.
I would also say, Judge, that, I'm sorry, Judge, I would just say one more thing, that the amount of pills that he had on his person, it's not an amount that makes it inconceivable that it could be used for personal use. Thank you.
Y otro argumento es que la cantidad de píldoras que se encontraron pudiera ser para uso personal.
Sí.
Yes.
Judge, there are, within the form, there's one bottle containing 97 pills, one bottle containing 30 pills, one containing 62 pills, one containing 47 pills, one containing 75 pills.
First, this the interpreter can be, it's kind of muffled, the interpreter couldn't hear you, I'm sorry.
I apologize. There are multiple bottles containing 97 pills, one containing 30 pills, one containing 47 pills.
Señoría, hubo varios frascos, pomos, como les llame, recipientes. Uno tenía 47 píldoras, el otro tenía 30.
One containing 75 pills and one containing 27 pills.
Uno tenía 75 y el otro tenía 27.
That is in no way, shape, or form arguable that is for personal use. That is an incredible amount, and no reasonable person would have that on them at one time.
De ninguna manera se pudiese pensar que esa cantidad de píldoras son para uso personal. Es una cantidad sustancial que nadie puede creer que sean para uso o consumo personal.
Judge, if an addict is taking one or more pills, several of those pills every single day as an addict would, that would be a several month supply, which is conceivable that an addict would have.
Señoría, esa cantidad
requires more.
Señoría, esa cantidad sustancial es válida para consumo de un adicto. Para alguien que esté comercializando tendría que tener más.
The focus of the challenge is the trafficking.
Yes, Judge, which I was about to get to, but when we turn to these, find 5 different phones, it says in the A form that this is commonly used in order to organize transactions.
Dice el fiscal, señoría, la tenencia o el estar llevando 5 teléfonos diferentes concuerda con la actividad comercial que haría alguien que esté dedicado al tráfico de este tipo de sustancias.
In light of the surrounding circumstances of the location and other factors, the court finds probable cause. Count 1, bond.
Este despacho halla a la luz de los hechos circundantes de que hay motivo fundado para el arresto. ¿Cuánto sería entonces la fianza para el primer cargo? Pregunta el juez.
Yes, Your Honor. The state would be asking for $25,000 bond for trafficking, $5,000 as to $5,000 is to removing the label, another $2,500 as to the cannabis count.
Señoría, la fiscalía está pidiendo una fianza de $25,000 para el cargo. State, I'm sorry for the interpreter, said $25,000 for what charge again?
Count 1. Count 1.
Got it, thank you. And then you said $5,000 for?
$5,000 for removing the label of the prescription drug.
And $2,500 for the cannabis, correct?
Correct.
Got it, thank you, State. Entonces, la la fiscalía confirma, son $25,000 de fianza para el primer cargo, $5,000 por el segundo, que es por el hecho de quitar las etiquetas de los recipientes, y $2,500 para la tenencia del cannabis.
And Your Honor, I can explain the bond on count one if you'd like.
Mr. Black, go ahead.
I'm sorry, what was that counsel said?
It wasn't him, it was,
It was me. I was saying I can explain my elevated bond on count one if you would like.
yes.
Yes, so as to count one, the reason for the elevated bond here, in 2021, the case closed. Illegal drugs trafficking, or at least a conspiracy to, was closed. We've got cocaine self-distribute a number of times, and he's also had his probation revoked a good bit.
Señoría, la razón por la fianza elevada es porque en el 2021, de hecho, el acusado cerró un caso que tenía que ver con tráfico de estupefacientes también, y en el pasado también tenía otro con tráfico de cocaína.
Judge, before I address the bond, can I please be heard as to PC for count 3, cannabis?
Sure.
So, Your Honor, a vape pen was found on Mr. Jaime de la Vega's person. There's no allegation that the officer tasted this vape pen, smelled this vape pen, read a label on it to know that it's THC. It is indistinguishable looking from a nicotine pen. What's more, Judge, legal THC vape pens are sold and legally purchased in every smoke shop in Miami-Dade County. There are unscheduled variants which are for sale and are not scheduled and are not prescribed under Florida law. And so there's no way to know that it's THC from the A form. And even if it was THC or cannabis, there's no way to know whether it is an unscheduled variant that is sold legally in Miami-Dade County and across the state.
El abogado defensor acaba de presentar un argumento para motivo fundado solamente para el cargo número 3, que tiene que ver con el cuestionarse si la sustancia era THC o cannabis.
Thank you. Probable cause found as to count 3.
El juez dice, también hallamos que hay motivo fundado para el cargo número 3.
May I be heard on the bond now, Judge?
Yes.
So as to the elevated bond on count 1, he can't afford that, which means that it's tantamount to no bond, which means he's going to be held no bond. Judge, the statute for pretrial detention includes trafficking under the possible charges to hold somebody no bond under pretrial detention, but it has to be under a certain subsection of 893, which includes fentanyl trafficking. So what's happening here is a workaround the PTD statute, which does not authorize him to be held no bond. The proposed bond amount is unconstitutional.
El abogado defensor acaba de presentar un argumento para tratar de que le reduzcan la fianza elevada.
Response by the state.
And it is clearly a threat to the community. He has been convicted in the last 5 years of trafficking. Now we're seeing him do it again. Or no, convicted. At least the case closed out in 2021. We have a history here of distributing cocaine in our community. This defendant is a threat to the men and women of this town, and thus we are asking for that $25,000 bond.
Dice la Fiscalía, señoría, nos mantenemos firmes en nuestra posición en cuanto a la fianza elevada de $25,000. Este individuo ya había cerrado en el pasado, en el año 2021, un caso que tenía que ver con tráfico de estupefacientes. Él representa un riesgo para la comunidad, para los hombres y mujeres de esta comunidad.
We just say one more thing, Judge.
Can we get a bond, please, Judge?
Again?
We're still arguing about the bond corrections. Okay, Judge, if I could just say one more thing as to the bond. We don't guess when people are unreasonable risk to the community. There's a subsection of the bail statute that lists those out. Trafficking is not one of those charges. It includes charges like terrorism, kidnapping, murder, violent charges, not drug trafficking.
In this case, Mr. De La Vega has an extensive criminal history of many of the very things you just said he has not been involved with. Under the circumstances, the $25,000 bond for count 1 stands. Next case, Jose Angel Fernandez.
I'm sorry, what was for Mr. Jaime de la Vega, what was count 2? Bond?
5,000. Fernandez. Yeah, Fernandez.
Look at that, you were not the number.
2,500. I mean, 25,000.
Right here, sir.
Good afternoon, sir. You've been charged with felony in the third degree controlled substance possession, fentanyl. Case number 893.13 subsection 6 subsection A. I've read the arrest form and I find probable cause. What is the bond?
$5,000, Judge.
Bond is scheduled and set at this time at $5,000.
And the bond is 2,500. Are you elevating the bond, Judge?
I'm elevating the bond. $5,000. Good luck to you, sir. Next case. Mario Savon.
Reset medical, Judge.
Thank you.
I'm sorry, Savon is medical or D?
And that will be reset tomorrow?
Yes.
Reset.
Sorry, just to clarify, is it medical? Is it Ward D?
Medical.
Okay.
Robert McKenzie. Mr. McKenzie, you've been charged with a third degree felony, possession of cocaine, suspected, Florida statute, chapter 893.13, subsection 6. Probable cause found. What's the bond?
An elevated bond of $5,000, Judge.
Bond set at $5,000 as to count one. Good luck to you, sir. Next case.
Judge, I'm sorry, what is the justification for the elevated bond?
3 pages of priors with an extensive history of drug-related charges and convictions.
I saw the same. I had those charges. Each one of these arrest forms, they hand up the charges as well to me. Edwin Jean. Mr. Jean, you've been charged with a second degree felony, retail theft with prior convictions of same violation of Florida statute 812.015 subsection 9. I've read through the arrest form, and in this case, find that probable cause exists for the arrest.
Judge, I have probable cause argument.
Yes, sir.
So, Your Honor, this is a mischarge here. So what's alleged here is a third degree felony. It's petty theft plus additional convictions. Retail theft is a specific thing. It requires an allegation of multiple attempts at the same store within a 120-day period. That's not what we have here. We have a petty theft from somebody who has 2 or more prior convictions.
Thank you. Mr. Rivas.
Judge. Yes, Judge, we'd ask you to find for probable cause for petty theft, 2 or more prior convictions. would leave probable cause to your discretion.
I concur with the public defender. He'll be released, no probable cause. Release. All right. Thank you.
Let's go.
Next case, Jabali Sanders. Mr. Sanders, you've been charged with a felony of the 3rd degree, being in possession of controlled substance cocaine in violation of Florida Statute Chapter 893.13, subsection 6, and a misdemeanor of the 1st degree by obstruction, disclosing information of internal investigation, a violation of 112.533, subsection 4. Taking a look at the arrest affidavit.
Your Honor, I do have something about count 2.
Momentarily, please.
Yes, sir.
I find probable cause as for count 1. Yes, I'll hear your arguments as to count 2.
So, Judge, I looked up this statute. It's not a criminal statute. I don't know what they meant to charge him with, but it's not a criminal statute. So there's no probable cause for, I guess they charge it as an N1 misdemeanor. It's just not a thing.
Mr. Rivas.
We would concur with the public defender's office, so that's to count 2.
Thank you. No probable cause as to count 2. Release outright as to count 2 only. As to count 1, the bond.
We'd be asking for an elevated bond in this case of $5,000.
$5,000, Mr. Black.
Your Honor, what justifies the elevated bond in this count? He was arrested under a criminal statute that doesn't exist, and then he was found with a suspected controlled substance, which was in an amount of personal use. He doesn't have an extensive history. There's no allegation that he doesn't show up to court. There's no allegation that he's a danger to the community. I was going to ask for ROR, Judge.
$2,500 bond, standard bond, not ROR. Good luck, sir. Thank you. Next case, William Lomanek.
Look like you got it. All them goals in your life, I know you got it. William?
This is Lomanek.
Yes.
Mr. Lomanak, you've been charged with a felony of the second-degree burglary of an occupied dwelling in violation of Florida Statute 810.02 subsection 3. Court finds probable cause. Bond.
We'd be asking for an elevated bond of $7,500 due to the circumstances of the case, as well as a conviction as early as 3 months ago.
Conviction for what?
As to loitering, prowling, and false name, as well as, yeah, that would be it.
Anything from the public defender?
I was having trouble hearing, Judge. What was the proposed bond from the state?
7,500 elevated based on a 3-month-old conviction that he's received for loitering and prowling, and the nature of the actual charge in this case.
No, I understand, Judge. I would just say that the dual concerns of the bail statute are return to court for proceedings and unreasonable risk to the community. Under the bail statute, there's specific criminal offenses for unreasonable risk, murder, terrorism, etc. He's not going to be able to afford 7,500, so it's tantamount to no bond. It's unconstitutional.
Judge, I'd like to hold firm on the 7,500. In less than 3 months, he has already picked up another charge after being convicted. That is a serious concern to the community.
Thank you. 7,500 bond. It is. Mr. Lomanak, you may not return to 7725 North Kendall Drive, apartment 122 at any time. Should you do so, you must remain at least 500 feet away from this residence and or not contact anyone that might reside therein. To do so would subject.
May I ask the name of my employer or my previous employer?
Good luck, sir. Next case, Geronimo Mendez.
Mendez.
He's out on probation, hold Division 10.
Right here, sir. Right here. You speak English? Speak Spanish.
Judge will need the services of a Spanish interpreter.
Got it. Thank you.
Thank you. Mr. Mendez, you've been charged with a felony as a third-degree assault with an aggravated assault, with a deadly weapon.
Señor, usted enfrenta un cargo que tiene que ver con agresión física con arma mortífera.
That as to count 1 is chapter 784.021.
Eso es un quebrantamiento del estatuto 784.021.
Also, you've been charged with a second-degree felony assault aggravated on a person 65 years or older with a deadly.
También enfrenta un cargo que es un delito grave en segundo grado, es agresión física a una persona mayor de 65 años.
This is a violation alleged of chapter 784.08 subsection 2.
Y esto es un quebrantamiento del estatuto 784.08, párrafo 2.
You are also charged in count 3 of this arrest form, second-degree felony, firearm, carrying a weapon and ammunition by a convicted felon in violation of 790.23.
Y también tiene un tercer cargo que es tenencia de un arma de fuego. Es un delito grave en segundo grado a manos de un criminal convicto. Es en quebrantamiento del otro estatuto de la Florida 784.
And count 4, a misdemeanor of the first degree resisting an officer without violence in violation of Florida statute 843.02.
Y tiene un cuarto cargo que es un delito menor que tiene que ver con resistirse a un oficial sin violencia en quebrantamiento al estatuto 843.02.
Read the arrest form. It is a two-page narrative.
Después de mirar el informe del arresto, es una narrativa de 2 páginas.
I find probable cause for all 4 counts.
Dice el juez Yayo que hay motivo fundado para los 4 cargos.
Judge, I have PC arguments.
Yes, sir.
So as to count two, Judge, the A form doesn't allege the age of the alleged victim. And so if that's not alleged within the four corners of the arrest affidavit, there's no probable cause for aggravated battery on a senior citizen. So that would simply be the F3, that would simply be an F3, which he's already charged with. As to
El abogado, one second, I'm
Sorry,
sorry.
yeah.
No, it's okay. Thank you. El abogado defensor dice que no hay motivo fundado para el segundo cargo que tiene que ver con agresión física a una persona mayor de 65 años porque no es lo que dice en el informe del arresto. You may continue, counsel. Thank you.
As to count three, Judge, there's no PC because if a convicted felon is carrying a firearm, that's PC for violation of the statute. If it's a non-firearm, if it's a weapon, if it's a knife, it has to be actively concealed on the defendant's person. It has to be concealed in order to be a violation of the statute.
Y el abogado defensor también está presentando un argumento de motivo fundado para el cargo número 3 que tiene que ver con la tenencia de un arma.
That's in the language of the statute, in the allegations in the arrest form. He's carrying it about his person. He's threatening people with it. There's no PC.
Entonces él dice que no hay motivo fundado para ese cargo.
Response by the state.
Sure.
Judge, we would agree with the public defender as to count two, the person 65 or older. However, when it comes to the firearm, weapon, ammunition, possession of a convicted felon, it does state that the defendant tried to conceal it. As we turn to paragraph 2 on page 2, it states that defendant then grinding the knife on the concrete sidewalk stated that someone is going to die today. And before my arrival, they observed the defendant stashed the knife on top of a wheelchair in a blue bag.
I'm sorry, stay for the interpreter. Stash the knife on what?
Stashed the knife on top of a wheelchair.
Got it, thank you. Dice el abogado, el fiscal dice que no hay problema para la objeción del segundo cargo, pero que para el tercero, dice el informe del arresto que con el cuchillo le dio encima, le cayó a una silla.
In a blue bag.
In a blue bag as well.
En una bolsa azul.
So, Your Honor, in order to be convicted under the statute, that concealment, it has to be on or about a defendant's person. It has to be on a defendant's person. That's what concealed means with respect to concealing a weapon under the statute.
Y el abogado vuelve a presentar otro argumento que tiene que ver en cuanto si el arma estaba escondida o no.
Thank you. Well presented by both sides. In this case, count 2, no probable cause. Release outright. Age 65 not contained in the A form.
El señor juez dice que entonces, después de escuchar el argumento de ambas partes, dice que para el segundo cargo sí le dan un excarcelamiento directo, que no hay motivo fundado para el segundo cargo.
As to count 3, I do find probable cause. It was concealed and it was within or about his person.
En cuanto al cargo número 3, si haya motivo fundado porque así estuviese escondida o no, estaba al alcance, la tenía en su persona y estaba a su alcance.
The bond amount for count 1, please.
An elevated bond of $5,000 for count 1, elevated bond of $7,500 for count 3, and elevated bond of $500 for count 4.
Está pidiendo entonces el fiscal una fianza elevada de $5,000 para el primer cargo, 7,500. State for the interpreter, you said 7,500 for 3 and 500 for 4, or did I get it backwards?
That's correct.
Okay, thank you. 7,500 para el tercero y 500 para el cuarto.
Court hereby enters the bonds accordingly. Good luck to you, sir. Thank you.
El juez acaba de ratificar entonces las fianzas de esa manera. Gracias.
Judge, can you read the bonds, please?
The bonds in this case, count 1, $5,000. Count 3, $7,500. Count 4, $500. And count 2 was no probable cause, release outright.
Thank you.
Thank you. Alan Napoleon Michelle.
Ya se puede retirar.
And Judge, before he leaves, if we can have a stay away order in this case.
Yes, Mr. Black, if you'll hold your client there for
Corrections, they need to read the, oh, he's gone. They needed to read the stay away order.
No, they gotta read something to him. No, he gotta come back. He needs to come back in. Do you need to read a stairway order properly?
Thank you, Mr. Mendez. At this
Gracias,
time,
señor Méndez.
you are prohibited from having any contact whatsoever with Alberto Levine, the alleged victim in this case. You must stay at least 500 feet away from the victim's home, place of employment, and you may not contact him by any means. Good luck to you, sir. Thank you.
Señor, a usted se le prohíbe mantener cualquier tipo de contacto con la presunta víctima, en este caso, el señor Alberto Levine. No se le puede acercar a menos de 500 pies de donde esta persona vive o trabaja, donde él se la pase en todo momento. No puede acercársele a él. Gracias.
Okay. We have the next case, which I believe he was there, Alan Michael. You've been charged with a third-degree felony, battery by a detainee on a visitor or other person, other detainee in violation of statute 784.082 subsection 3. In this case, I find probable cause. The bond, please.
Standard bond, Judge, $2,500.
$2,500 bond approved. Good luck to you, sir. Thank you. Next case, the case of Ronaldo Fernandez Martinez. It says here, send to division judge, case already has a bond, arraignment set for May 27th.
Oh, that's an arrest warrant case, Your Honor. He was already previously arraigned. He already had a set bonds. And so now it's just for calendar. Out of necessity, but it should print in division on, if not Monday, as I said, they said the 27th, they'll be in division.
All right, so what action do they wish me to take?
Stay on the record. Well, he did have a first appearance here, but just to state on the record that he should be in division, not in bond.
Thank you. For the record, Mr. Black, and for the state, Mr. Rivas, I find with the help and assistance of the clerk's office that this should have been set in division. It's currently set for arraignment on May 27th before the division judge. And so we'll take no action here today. Good luck to you, sir. Thank you.
So Your Honor, my question is, are these,
bonds have already been set for him?
it's already been set at no bond?
Yes. No,
That's on which case, Judge?
This is the case of Ronaldo Fernandez Martinez.
The case number.
The original bonds were 2,500 for all 8 counts.
The original bond were $2,500 for all counts.
Which case number?
It's not written on the arrest warrant there. 7673.
7673, she said.
So just so I'm understanding, he was arrested on an arrest warrant for 7673, and the arrest warrant was a no bond arrest warrant?
It originally was no bond, but the judge decided to grant 2,500 on each.
Did you like?
I couldn't hear it. I'm sorry, Judge.
He said that it was originally no bond, but then the judge reconsidered and issued bond, as we previously stated for.
Okay, so 2,500 times 8 for 7673.
Correct. Next case, Johnny.
Okay.
Excuse me, Judge.
Yes.
Going back to Fernandez Martinez, on the case ending in 7767, what is the bond amount? So it's on calendar for bond review.
That's not report. Set for Monday at 9 a.m.
She has indicated that he has bond review scheduled for Monday at 9 a.m.
He just has 517 bond review.
So I think what that means is that 7767 will be before the felony court on Monday for bond review. I don't think it's something that we engage in. I'm not sure.
He's correct. Mr. Black's correct. All right. Can we call to the podium Johnny Estevez, please?
Okay. Hi, do you need an interpreter? No.
Mr. Estevez, you've been charged with a third-degree felony, being in possession of a controlled substance, suspected cocaine, in violation of Florida Statute 893.13, subsection 6. In this case, I've read the A form, and in this case, it was otherwise admitted by the defendant that what he had in his possession was cocaine. I'm finding probable cause. What is the bond amount?
Standard bond, Judge.
Standard bond, $2,500. Good luck to you, sir. Thank you.
Your Honor, he's not going to be able to afford that. Can we give him PTS, alt bond? He's got an address.
Grievous. Any objection to alternate bond pretrial services?
No, Judge, he doesn't have any felony convictions.
This will be an alternate bond. Pretrial services approved if he is eligible. Thank
Just
you.
gotta give him your address, okay?
Yeah, that's my address.
Okay.
Okay. I'm good?
Yep.
Free to go?
Mr.
Miller, I think.
Miller?
Good afternoon. Mr. Mendez, you've been charged with a felony of the third degree cocaine possession, white rocky substance suspected as cocaine in violation of Florida Statute 893.13, subsection 6. Based on the arrest affidavit, I find probable cause. Bond, please, Mr. Rivas.
Standard bond, Judge.
$2,500 bond.
Judge, he's not going to be able to afford that. Can you give him PTS? He's got an address.
Any objection?
If he qualifies, Judge, no objection.
Alternate bond. 2,500 pretrial services. Good luck to you, sir. Next case of Herbert Miller.
So who was the previous defendant? Did you get 2,500 to?
Was that gentleman leaving the podium right now?
It's Herbert Miller, corrections, 26, PTS alt bond, standard bond.
No.
That was
Oh.
Hernandez Mendez pretrial services.
No, it's both. It's both Hernandez and Miller.
The previous, just at the podium with you, Mr. Black, we thought was Angel Augusto Hernandez Mendez, or no?
So the immediately previous one, Judge, was Herbert Miller, and then the one before that was Angel Hernandez, and you gave them the same.
No,
same bond.
Herbert Miller, I just now called.
Yes, it was.
Ask that gentleman sitting next to you, is he Herbert Miller?
No, this is St. Fard.
Because we had, the last individual was supposed to be Angel Augusto Hernandez
The
Mendez.
last individual, and I should have asked him his name, was supposed to be Angel Augusto. Could you ask the last person, that taller young man, ask him to step back, please?
Yeah, that was Mr. Miller. Yeah.
Well, I read the wrong.
Okay.
Ask Mr. Miller to return, please.
She can't stand like that.
And then we're looking for this other fellow. The rocky substance case.
Almost the same allegations, Judge.
Almost. Who is the gentleman standing to your right, Mr. Black?
This is Mr. Herbert Miller, Judge.
Okay, that's who was standing up in front of me just moments ago. All right. We're still looking for Angel Augusto Hernandez Mendez. So if corrections could also have him in the wing waiting, I'll call him next, back up. Mr. Miller, you've been charged with a third-degree felony of possession of crack cocaine, rocks, Florida Chapter 893.13, subsection 6. In this case, based on the arrest form, I find probable cause. What is the bond?
Standard bond, Judge, $2,500.
2,500. Any objection to an alternate bond?
No, Judge.
Alternate bond approved. Pretrial services eligible if he can do so. Let's call back Hernandez Mendez, please. I don't think so. We'll have to go all the way back to the beginning.
I think it was from Johnny Esteves on.
Mr. Mendez, what is your name, sir?
Angel Hernandez.
Thank
Hernandez.
Great. Ask him, Mr. Black, if he's willing, under the circumstances in light of the felony third-degree cocaine possession, to accept an alternate bond pretrial services of $2,500.
He would like that, Judge. Thank you.
Thank you. Good luck to you, sir. Our next case will be the case of Davidson St. Fjord. Mr. Davidson, you've been charged with a felony of the third degree, being in possession of crack cocaine, count 1, chapter 893.13, subsection 6. Count 2, felony of third degree, controlled substance possession suspected as crystal meth in violation of 893.13, and controlled substance possession suspected cocaine, felony of the third degree, 893.13, subsection 6. Taking a look at the arrest form. Find probable cause for the arrest. In this case, the bond.
We'd be asking for an elevated bond of $4,000 per count.
Elevated bond, $4,000 per count, Mr. Black.
Judge, what is the basis? What is the justification for the elevated bond?
The extensive criminal history of this gentleman, conducting many, since going back to 2008, drug possession, arrests, and convictions.
Your Honor, I would just object to the elevated bond. It's tantamount to no bond. He can't afford it. The concerns of the bail statute are an unreasonable risk to the community. It sounds like he's a risk to himself mostly, and also a likelihood of not returning to court. I don't think there's any allegation of escape or something of the kind in his record. So I'd ask for a standard bond, Judge.
Denied. Good luck, sir. Thank you. Next case.
So it's $4,000 each, Judge?
Yes, sir. Carlos Humberto Gomez.
You'll hear from an attorney in the next few days. Just hang tight.
Here I do it again. I did it again. So sorry. Augustin Tessa Gomez. Augustin Clemente.
Yeah.
There we go. Yes. Mr. Clemente, you've been charged with a third-degree felony of aggravated stalking in violation of court order, Florida Statute 784.048. Count 2, third-degree felony, fleeing and eluding a police officer in violation of Florida Statute 316.1935. And count 3, misdemeanor in first degree domestic violence and a violation of the domestic violence injunction. That is chapter 741.31 subsection 4 Florida statutes.
This is an added charge, Judge.
Thank you.
So, Your Honor,
Or can we
Mi-
call him right now?
Mr. Clemente has a private attorney and he asked to reset to tomorrow so that his private attorney could attend bond hearing.
The objection by the state.
No objection, Judge.
Reset tomorrow to allow counsel for Mr. Clemente to appear on his behalf.
Can I have these charges?
Okay. In this case, we're not gonna need that till tomorrow, maybe. Next case, Jordan Tyler Pinkney. In this case, Mr. Pinkney, he was out on bond and he's to be held for Division 10. You've been charged with a felony of the first degree burglary with an assault or battery, PBL, Florida statute, chapter 810.02, subsection 2. Count 2 is felony of the third degree, grand theft in the third degree, violation of Florida chapter 812.014, and misdemeanor of the first degree, indecent exposure in violation of Florida statute 800.03. Give me a moment, I'm going to read the arrest form. All right. After reviewing the arrest form and the narrative contained therein, court finds probable cause for the arrest. In this case, he was out on bond, so he's being held. There's a request for motion for pretrial detention. So at this time, as to all counts, I'm granting the pretrial detention hearing request by the state. Based on the surrounding circumstances as well, prior criminal history with respect to these areas here.
That is, the counts will be no bond.
Correct. Yeah, I thought. No bond as to counts 1, 2, and 3.
Bro, no.
I think it would only be as to count 1, but it doesn't make a lot of practical difference for him, but I do think it's only as to count 1.
Only has to count 1, Mr. Rivas?
It will be just one.
With respect to count 2 and 3?
We'd be asking for an elevated bond of $5,000 to count 2 and to $1,000 for count 3.
$5,000 bond as to count 1, 5,000 bond as to count 2. Approved.
Count 3 was 5,000 as well, 1,000.
No. It's held no
What's that?
bond 1, 5,000 2, 1,003.
Dexter Jamal Khan.
Come on, sir, you finished?
You gotta go before that court first.
Expert.
Whoever that judge is, you gotta go before that.
Judge, on count 3 for Mr. Pinckney, you said 1,000, correct?
5,000.
I'm sorry, let me take a look just so I'm clear. No bond, count 1. Count 2, 5,000. Count 3, 5,000 for Mr. Pinckney.
Thank you.
In this case, Mr. Cohn, you've been charged with 2 counts, 1 felony, 2nd degree, being in possession of a controlled substance with the intent to sell. This all happening allegedly within 100 feet of a church or a convenience store. Count 2 is a 3rd degree felony of being in possession of a controlled substance, cocaine. I find probable cause. In this case, count 1.
Judge, we'd be requesting bond to be set, an elevated bond to be set in the amount of $20,000. The reason why is the defendant was convicted for possessing a controlled substance on the 5th of this month.
Count 1, $1,000. Count 2.
Standard bond, $2,500.
Standard bond, count 2, $2,500. Good luck, sir.
I'm sorry, Judge, what did you enter as the first count bond?
20,000.
Yes. So Judge, we object. For the record, it's tantamount to no bond.
Overruled. At this time, stay away order from the location where he was arrested at 2050 Northwest 54th Street, Miami, Florida 33142. Good luck to you, sir.
I know. An attorney's gonna be in touch in the next few days, okay, to try to resolve the case. This case will resolve, all right? I know.
You didn't even get it off me.
I know.
Ex-defendant, Yayo Alderete.
Who is this?
This is
Oh, sorry.
Alderete.
Is this
Right
Alderte? Yes, Alderte. Okay. Thank you.
Good afternoon, sir. You've been charged with a felony in the 3rd degree, anti-shoplifting, inventory device use, attempted to use. In this case,
I'm sorry, Judge. I'll need the services of the Spanish interpreter.
thank you.
I'm sorry, Your Honor, the interpreter was not aware. What was the charge again, Your Honor, please?
Yes, the charge, count 1, 3rd degree felony, shoplifting, and trying to use an attempted anti-shoplifting device in violation of Florida Statute 812.015.
Statute, what number again, Your Honor, please?
812.015, subsection 7.
Got it. Thank you, Judge. Señor, usted enfrenta un cargo es un delito en 3er grado, un delito mayor, tiene que ver con hurto a establecimiento comercial y también por alterar un dispositivo antihurto en quebrantamiento al Estatuto de la Florida 812.015, párrafo 7.
Thank you. At this time, the court has reviewed the arrest form. Under the circumstances, the court finds probable cause. Bond, please.
Bond, we'd be asking for standard bond as to count 1, $2,500, and as to count 2, $150.
Este despacho haya que motivo fundado para los cargos a la luz de lo expuesto y le pregunta al fiscal cuánto es la fianza. El fiscal dice, señoría, la fianza estándar para el primer cargo serían 2,500, para el segundo cargo serían 150.
Thank you. Also, sir, if you're eligible and make bond and are released, you may not return to the TJ Maxx store where you were arrested at 8546 Southwest 24th Street, Miami, Florida. And if you were to return, you must stay at least 500 feet away from the location. If you were to return, you may be subjecting yourself to rearrest. Good luck to you. Next
Señor, y
case.
si usted llega a salir, entonces tiene que mantenerse alejado de la tienda TJ Maxx que queda en el 8546 de la 24 calle. Tiene que mantenerse por lo menos alejado a 500 pies de ese lugar. No puede regresar allá.
Thank you. Next case. Defendant
Gracias.
Turnbull.
Se puede retirar. Se puede retirar.
Mr. Turnbull, you've been charged with a third-degree felony of burglary of an unoccupied conveyance in violation of Florida Statute 810.02 subsection 4.
And Judge, I'll have a PC argument.
Very good. We'll hear from you, please.
Your Honor, burglary requires an allegation of an intent to commit a crime subsequent to the burglary. What we have here in this arrest affidavit is simply allegations of trespass upon a conveyance, an unoccupied conveyance, which is an M2 misdemeanor. There's no allegation of any intention to commit other crimes or any other crimes being committed.
Mr. Rivas.
Judge would be asking if this court would find probable cause for trespass onto an unoccupied conveyance instead.
I'm sorry, I didn't understand.
That we'd be asking, while I would agree with counsel as to burglary, we would ask, and we would see here on the A form that there is probable cause for trespass onto an unoccupied conveyance.
That's fine. Do you have to amend the charge?
It'll be amended to division, Judge.
So under the circumstances, I find no probable cause. Would that be correct, Mr. Black?
So you would find no probable cause as to the burglary count. It's within your discretion to find probable cause as to an M2 and to set a corresponding bond.
Corresponding bond for the M2 probable cause would be?
It would be $500.
Your Honor, in this case, I would ask if we could, because he's not going to be able to pay even $5. I'd ask that we set this on a homeless calendar with a date certain.
That is nice.
I would be, under the circumstances, I can give him the alternate bond, pretrial services. Would that be acceptable to everyone?
No, that requires that he have an address. He's homeless, but if we give him a date certain on the misdemeanor jail's homeless calendar, I think the state may have that date. We just give him a piece of paper that says return on this date, and if he doesn't, then he'll get a bench warrant.
That's in the misdemeanor court. I'm being instructed by the clerk, not in the felony division.
No, that's accurate, Judge, but since it's only an M2 now, it's going to go to jails in misdemeanor court under Judge Correa anyway.
If we did want to set up things, we can't do it.
How would we correct the charge or amend the charge?
That's up to the state and they're filing this.
You can still find probable cause for the misdemeanor, we just can't put it on the tab.
You can, I mean, the homeless calendar, but you can put it in tap if you wanted to, but
Mr. Black, if you heard, they said he could be placed in TAP.
but he probably won't be released until after Monday because tap is not around on the weekends.
Yes, the release would be Monday or thereafter because they're not available for intake on the weekends.
Listen, we'll take TAP over the 500. I would just only suggest that if we put them on Judge Correa's homeless calendar, they will be able to file a correct information in court.
They're indicating we can't do it in that manner.
Okay.
No, that's what TAP is. TAP is the homeless calendar. That's what, when you put in the criminal homeless division, that's what TAP is.
In this case, the clerks are indicating to my naivety of not having served many days in the Richard E. Gerstein building as a judge, although this is my 27th year on the bench. TAP program is almost equivalent, if not, to the homeless calendar date. So
okay,
So I think they're comfortable that that's what'll happen, okay?
Okay.
So your client can be as well comfortable in that regard. Any objection by the state?
No, Judge.
Thank you. Tap it is probable cause, yes,
500.
misdemeanor of the second degree. Mr. Turnbull, if you're able to be released, you shall not be within 500 feet of the victim of this alleged incident, Nestor Quintana. Do not contact that person. You shall not go to that person's home, place of employment, or school, and you'll remain 500 feet away from him at all times. Do you understand, sir?
Yes.
And staff requires an alternate bond.
500, that's what they.
And that's what we can do. Alternate bond 500, which is what I had in there to begin with. As they would say, alternate bond 500. Thank you. Next case, Cornell Blunt.
Go ahead. Come on, Mr. Blunt.
Mr. Blunt, you've been charged with a third-degree felony and being in possession of cocaine plus or minus 1.5 grams suspected crack in violation of 893.13 Florida statute. Also, second count misdemeanor of the first degree, being in possession of cannabis, 20 grams or less, and plus or minus 1 gram of suspected cannabis. Also in violation of 893.13 subsection 6. Probable cause is found in this case. What is the standard bond?
Your Honor, can I make a brief PC argument as to count 2?
You may.
Your Honor, legal cannabis, loose leaf cannabis is sold in every smoke shop across Miami-Dade County. It can be CBD, it can be variants that are not scheduled. And so there's no way for these officers to know that this is illicit marijuana. And it's not alleged to be specifically illicit versus non-illicit in the 4 corners of the arrest affidavit.
Response, Mr. Rivas.
Judge, when looking at the 4 corners, it says that there is plus or minus 1 gram of loose cannabis placed within 0.5 grams of a suspected crack cocaine. That's in that tobacco leaf. When looking at the 4 corners, this would satisfy a probable cause finding for this charge.
I concur. Probable cause found as to both counts. And
we're asking for tap.
I think he is suggesting he be placed in the TAP program with an alternate bond.
Yeah, no objection. If
no objection, the alternate bond amount is?
It would be. It would be $2,500 for count 1 and $500 for count 2.
All right, very good. TAP approved. 25. These are alternate bonds. Good luck to you, sir. Thank you. Case of James Crescent. Mr. Crescent, you've been charged with 3 counts. The first count is felony of the 3rd degree, controlled substance possession, alparalzum, which is Xanax by its name. Florida statute 893.13 subsection 6. Count 2, misdemeanor of the 1st degree, drug paraphernalia with the intent to use or inject, violation of Florida statute 893.147 subsection 1. And count 3, misdemeanor of the 1st degree, cannabis possession, 20 grams or less, marijuana, 893.13 subsection 6. Taking a look at the arrest form. Court finds probable cause. Count 1, bond.
$2,500.
Count 2.
500.
I don't have any.
Count 3.
Your Honor, can I be heard as to probable cause?
You may.
So just renewing my argument for counts 2 and 3. Legal cannabis, loose leaf cannabis is sold in every smoke shop in Miami-Dade County. There's no allegation that it's illicit versus non-illicit, which can be bought again in every smoke shop in Miami-Dade County. So there's no PC, Judge.
We stand on our argument from the previous case, Judge. It says marijuana, and that would be enough to satisfy for probable
I'm
cause.
going to request tap, which could possibly.
And we have no objection to that.
In this case, they would have no objection to a tap. I'm going to find probable cause as to all three. Tap, alternate bond, in essence. Back to you, sir. Thank you. Thank you, Mr. Black. I think that concludes the afternoon. You've done an excellent job, as Mr. Rivas and Mr. Lovelace, who have been here all afternoon and all morning. I want to thank our clerk and our corrections officers and all of the Miami-Dade's finest who have helped me here today. And just for the absolute fun of it, I'm coming back tomorrow because I enjoyed it too. We'll see you at the adventure. I want to thank our videographer and coordinator for our program today and our wonderful interpreting staff and all the clerks that helped me. Good luck. We'll see you tomorrow at 9 o'clock for the juvenile proceedings. Have a nice day.
Thank you. Thank you. Good afternoon, y'all.
Okay. So I don't know if I need to turn this.
Okay, so all these open meetings are for, yeah, you just take them back.
I think what I'll do, since I've got to move around a couple of times, I'll take the tag with me so that I don't forget it. Yes, that's my stamp there. I see the senior judges back in the senior judges rooms have those fancy stamps. I gotta get me one. I am now the second most senior county judge in the county. I was appointed by Lawton Childs in 1997. 27 years. I just got reelected unopposed, thank goodness. And my father, who's the United States Federal District Judge, he was appointed in 1970 by Richard Nixon, one of the few Democrats ever appointed well, he appointed a few, but at the time, the Senate Judiciary Committee controlled by the Democrats controlled the House, but the White House was controlled by Mr. Nixon. They did a horse trade and they said, we'll take 2 Republicans for 1 Democrat. That's how my dad became a federal judge. And we found out about 3 or 4 years ago, the constitutional revision of the state of Florida's constitution raised the retirement age to 75. I'm 68. So I would have only been able to serve originally to 70. It used to be 70, but they raised it to 75. I called my dad, who's 97 now. And only about 4 months ago, he kind of slowed down to the point where he wasn't going to handle court any longer downtown. But up until age 97, my father was handling cases for the United States District Court. And I said, we have to retire now, Dad, at 75 state judges. He goes, oh, I was just getting started then at 75. So there you go. And he's still sharp as a tack. He lives over in Pinecrest, and his law clerks, that's really what happened. His law clerks took private sector positions. I think I may have dropped some. And and so the chief judge, the current chief judge, said, well, probably time we bring it to a close, but he really enjoyed it. He currently with Judge Choklat from the 11th Circuit Court of Appeal. They went on the court at the same time. They were sworn in the floor of the United States Senate in November of 1970. Are the 2 longest serving federal judges in the history of the United States of America, 55 years. And Dad was the state circuit judge for 6 before that. But they talk to each other every so often. Chief Judge Choklat was the chief judge of the 11th Circuit Court of Appeal. Anyway, there's a little history for you. So, you know, just when you think you guys are just starting out, right? And I'll go that way. I blinked like that. And the time went by so quickly, it's amazing. But you guys have got 70 years. Yeah. Well, in the state of Florida, after 10 years, we become a judge, and one of the best training facilities in the world. That's the United States, excuse me, is the 11th Judicial Circuit State's Attorney's Office and Public Defender's Office for new judges. As a matter of fact, I'm going to tell you probably half of our court came from both of those offices. I didn't. I was a civil litigator my whole life before the governor appointed me. Nice to see you all. And I guess you guys won't be back tomorrow. They got a new crew. Yes, sir. Thank you. Have a good day. We can help. No. I'll take. Now.